Kia ora, Leonie. Good to see you there. We've welcome to the Justice Subcommittee. We've got you for 10 minutes today. So in the interest of time, I'll hand straight over to you to speak to your submission. Kia ora.
Kia ora. Ngā mihi nui kia koutou, kia tātou, ngā mema o te komiti, ngā tangata kua tai mai mā rorohiko. Ko waiahau, ko manawa whākua tōku ingoa, huri ahau no Ngāti Tūwhare tō ki Taupō, Ngāti Kahunganu ki Here Taunga. Ko au te tumuaki o te ropu mō ngā Pākehī Māori o Tauranga Moana. He roi ahau, he kaiwhakahaere no te tari o Harris Tate ki Tauranga Moana. So just acknowledging the committee, a huge mihi thank you for the opportunity to present this morning, and also acknowledging anyone that's attending online this morning. So my name is Leonie o Manawa Whākua. I am the chair of the Tauranga Māori Business Association. I'm also a lawyer and director of a firm named Harris Tate Lawyers in Tauranga. So I'm here this morning representing the board of the Tauranga Māori Business Association and also our members of the association and opposing the Treaty Principles Bill. I understand that our written submission will be taken as read. So what I'm planning to do this morning is just address some of the key points that we made in our submission. Just to start off with, just in terms of who we are as an organisation, we're made up of a board of 7 members who are leaders in various industries. We represent Māori businesses in Tauranga Moana who whakapapa mai ngā haue whā from iwi across the motu, including the 3 main iwi of Tauranga Moana, Ngāti Ranginui, Ngāti Rangi me Ngāti Pukenga. We provide business support and various opportunities to our members, including education, networking, advisory services, promotion, and other opportunities. Our business owners also operate in quite a wide variety of industries, both locally, nationally, etc., from tourism, hospitality, construction, horticulture, and a variety of service industries, including legal, insurance, accounting, etc., quite a wide range. So Māori business owners and our Māori business owners that are part of our organisation, they do not just focus on economic success, but on success that ensures the overall well-being of their whānau, their communities, the environment. Our business owners are focused on making what we call mokopuna decisions, decisions that will have a positive impact on generations to come and are not just focused on what you can achieve for yourself and everyone that's here today. So as an organisation, we oppose the Treaty Principles Bill for a number of reasons. Firstly, the bill, in our view, is a breach of Te Tiriti o Waitangi in and of itself. It is an attempt to rewrite Te Tiriti and fundamentally undermine its core principles. The Article 2 guarantee to Māori of tino rangatiratanga over our land, villages and other taonga, including our reo, is gone, unless agreed to in a deed of settlement. The commitment to protecting Māori and ensuring Māori have equal rights is gone. And this has been done from, at this stage, in terms of the proposal, one party's perspective, not even a tiriti partner. It is against fundamental principles of contract law to unilaterally rewrite a contract that has been entered into between 2 parties, particularly one with such historical significance as Te Tiriti o Waitangi as a founding document of Aotearoa. There's been no consultation with Māori before the bill was presented to Parliament and has since been put forward for public submission. This is again against Te Tiriti itself and the principles of partnership and good faith, which flow from Te Tiriti and which the Crown has a responsibility to uphold. It's a takahi on the mana of our tupuna who signed Te Tiriti, so it's stomping on their mana. By not providing explicit mechanisms for safeguarding Māori rights, interests and cultural identities in the bill, if the bill is passed, the government will be neglecting its obligations to Māori, and this is detrimental to fostering the trust, respect between Māori and the Crown, which should be the foundation of our relationship. The bill purports to promote equality, but ignores the need for equity. It fails to include any purported consideration or recognition of the Crown's breaches of Te Tiriti to date and the impact of that on Māori, including in terms of the loss of our land, our reo, and for many our culture. Māori tino tiratanga was not preserved and protected, as was promised. Our reo was not protected. Instead, our tupuna were beaten for speaking te reo. Our land was not protected. Instead, our land was confiscated or purchased at significant undervalue, with Māori as kaitiaki not understanding the concept of ownership. Our tupuna were treated as second-class citizens, and in lots of ways, this still continues today. In my submission, the Crown has a continuing obligation under Te Tiriti o Waitangi to do everything it can to right those wrongs and provide Māori with the support needed so that Māori are brought onto somewhat of a level playing field. This is despite the challenges, given the deep-seated nature of the Crown's breaches and the effects of this. Treaty settlements are not enough to achieve this. We still see the effects of the Crown's breaches of Te Tiriti o Waitangi today. We see this with our business owners and their struggles, their inability to speak te reo Māori, the impact of this on their identity, and almost everyone that we speak to being on a journey to revitalise or even learn their reo. Our business owners' financial struggles, the reasons for creating their own businesses, including a desire to create a legacy for their whānau and future generations, the challenges and frustrations that come with navigating systems and policies that often disregard our fundamental rights as Māori and are not fit for purpose. If these issues have not already been adequately addressed when we're applying the principles of Te Tiriti o Waitangi as we have them today, as we understand them to be today, then any future application of the principles of the proposed Treaty Principles Bill is clearly going to have a detrimental impact on Māori. Again, reminding everyone that in the bill, our tinoranga, the acknowledgement and recognition of our tino rangatiratanga is gone, active protection is gone, and the commitment to ensuring equality for Māori is gone. So the bill disregards all of these issues. We ask on that basis that Parliament reject what we see as a divisive and ignorant piece of legislation. We recommend that Parliament move forward with a focus on moving forward in the spirit of Te Tiriti o Waitangi with a genuine partnership with Māori. This would include engaging and meaningfully consulting with Māori in good faith, governing Aotearoa in partnership with Māori, building relationships founded on respect, transparency and shared decision-making, and investing in initiatives to improve outcomes for Māori.
I've just noticed we're almost at time, but we've got a question or two. Could we go to questions? Would that help?
That's fine if you have a question.
Let's go to Tākuta had his hand up first, so let's go to Tākuta. I think that's all we have time for.
Tēnā koe e te tuahine I o kōrero. One of the things, the government and ACT, they present themselves as being, quite onto it when it comes to business and the economy. And given that the Māori economy is like 50% of fishing, 40% of forestry, we're about 20% of sheep and beef, 12 or 13% of dairy in the country. What does this bill communicate to our Māori business community about how the type of support we can expect in growing our community? Not to mention that 30% of our kids are going to make up the future workforce. They'll be 30% of their workforce. So what does this bill and all of this action communicate to our Māori business economy?
It basically communicates that, our government is not going to adhere to promises that were made before, that we're not going to be provided with the support that we need, particularly in light of the historical grievances, that the issues that we're facing already are just going to be exacerbated. It's going to be worse, and it's scary. A lot of our business owners are in true fear for what the impact that a bill like this will have on not only them, their whānau, their mokopuna, but actually on Aotearoa as a whole.
Kia ora, Leonie. We're over time, but thanks. I thought it'd be useful to get that question in rather, but thank you for your contribution and thank you for your substantial written submission. Kia ora.
Ngā mihi nui kia koutou.
Members, our next submitter is David Dorbar, and we have David for, I see we've got Rawari rather than David, but that's all good. We'll just wait for him to come online.
Oh, well, I'm here.
Kia ora, Rawari, good to see you. We've got you a very short submission that you're here to speak to, and I think we've got you for 10 minutes, so I'll hand straight over to you. Kia ora.
Okay, I'm going to cut it a bit fine, but please allow me to finish. E ngā mana, e ngā reo, e ngā karangatanga maha tēnā koutou.
We've just got 10 minutes and we'll be...
My name is Rawari Dorbar. I'm of Otarawa, of Waitara, and here to oppose the principles of the Te Riti o Waitangi Bill on behalf of our hapu and whānau. The Te Riti o Waitangi is a foundational agreement affirming the sovereignty, rangatiratanga and self-determination of our hapu and whānau. The Henry Williams copy was signed by our rangatira in 1840 in good faith, ensuring our tino rangatiratanga over our land's taonga and our way of life. E whakapūtanga o te rangatiratanga o Nutere in the 1835 Declaration of Independence remains legally recognised. Oh, shit. The Crown has both feudal and fiduciary obligations to uphold Māori self-determination and act in good faith. A quick historical context: systematic breaches of Te Tiriti, the colonial government, in direct contradiction to the guarantees within Te Tiriti, initiated military invasions, raupatu confiscation and legislation designed to dispossess us of our whenua and resources. The Waitara invasion of 1860 exemplifies the betrayal of the Tiriti, where military force was used to alienate us from our whenua. Successive settler governments have used legislative trickery, Native Land Acts, New Zealand Constitution Acts, Resource Management Acts to systematically dispossess our people. Māori self-governance was originally protected under the 1846 and 1852 New Zealand Constitution Acts. The removal of these legal protections by the New Zealand Parliament constituted an act of treason under British law. Despite numerous commissions and reports recognising these injustices, successive governments have failed to fully restore the rights and lands wrongfully taken. There's never been any justice provided to us. The Treaty Principles Bill is a direct assault on the Te Riti o Waitangi. The principles of the Te Riti o Waitangi Bill represent an explicit and intentional direct assault on us. It distorts the principles of the Te Riti o Waitangi to fit a colonial framework that erodes our rights as Te Riti partners and consolidates state control. The bill is a calculated manoeuvre to strip tangata whenua of our rightful tino rangatiratanga and to redefine the Crown's obligations in a way that serves only settler government interests. A colonial government has no right to arbitrarily interfere with the confident of the Te Riti o Waitangi. The Crown's representative has no mandate to alter, redefine or undermine this relationship to suit the political interests of the settler government or its incorporations. The continued interference, legislative overreach and resource theft must end. This government must stop manipulating our Te Riti relationship and cease the ongoing marginalisation of our people and the rape of our lands, waters and our taonga. We see this bill as a deliberate strategy to provoke crisis. The introduction of this bill strongly suggests that the Crown is not simply redefining its obligations, but is deliberately escalating tensions to justify the suppression of our rights. If history has shown us anything, it is that colonial governments do not give up power willingly. We are being pushed into a corner so that the full force of the state can be used against us. If we resist, we will be criminalised and labelled as extremist, just as our tūpuna were. If we comply, we allow the continued erosion of our rights and tino rangatiratanga. If we disengage, the settler government will claim Te Riti o Waitangi as irrelevant and move to dissolve it altogether. This is not simply semantics, nor is it about justice or fairness. This is about the government manufacturing consent for further state action against our people to secure the exploitation. As Governor Gore Brown declared in 1859 in his greed for our lands and resources, lecti si posent si non qualcunque modo. If it can be done honestly, do so. If not, do it by any means necessary. Racist battle fatigue and intergenerational harm. The racist battle fatigue from our perspective is not just an individual experience, but an intergenerational burden carried by our people as we continuously resist the structures of colonisation that seek to dispossess us. It is the exhaustion that comes from having to constantly justify our existence under our rights under the Te Riti o Waitangi, our tino rangatiratanga, in the face of a government that has, for generations, weaponised dysfunction as a tool of control. One of the most insidious tools of the strategy is economic dependence. The government ensures our people's reliance on state unemployment benefits and solo parenting support as a means of social and economic control. By keeping our whānau trapped in a cycle of poverty, the state prevents the development of intergenerational wealth, limits self-sufficiency, and keeps our people preoccupied with survival instead of resistance. This strategy diverts attention away from the Crown's systematic theft of land and resources while reinforcing the false narrative that our Māori people require state intervention to function. This deliberate suppression erodes the wairu of individuals, fragments whānau, and forces our people into colonial systems that are designed to fail us. Over time, this fatigue manifests in intergenerational trauma, where the battles fought by our tūpuna become the battles of our tamariki mokopuna, perpetuating a cycle that the colonial state relies upon to maintain its hold over our whenua and futures. Racist government fatigue, a systemic assault. Every day we endure the consequences of colonial rule in justice, education, health, housing, environmental management, social services, and economic opportunity. The justice system criminalises Māori disproportionately, ensuring high incarceration rates and ongoing state control over our people. The education system continues to erase our history, suppress our languages, and fail our tamariki at every level. The health system neglects our people, with Māori suffering from the worst health outcomes due to systemic bias and underfunding. The housing sector has made home ownership unattainable for many Māori, pushing whānau into homelessness and intergenerational poverty. The environmental policies continue to prioritise corporate interests over kaitiakitanga, stripping us of our control over our whenua and our waterways. The social services sector intervenes disproportionately in whānau Māori, removing tamariki from homes under policies reminiscent of colonial child removal practices. The economic system is structured to maintain whānau dependency while profiting from the ongoing exploitation of our natural and cultural resources. These are not isolated issues, they are deliberate and coordinated components of the ongoing colonial project, a system designed to keep our people suppressed, dispossessed, and politically neutralised while continuing to extract wealth from our whenua and resources. But despite this, we continue to rise, drawing strength from our whakapapa, mātauranga, and the unyielding commitment to restore what was taken. The challenge is not just in resisting oppression, but in reclaiming the space to thrive beyond the limits imposed upon us. In conclusion, the principles of the Te Riti o Waitangi Bill represents the ultimate betrayal of the foundational agreement between our people and the Crown. It must be abandoned. The fight for justice, for sovereignty, and for the future of our mokopuna will not end here, it will grow stronger. Our tūpuna stood firm, and so do we. These are the words of Te Rangi Puahuaho, a rangatira of Ngāti Mutunga, when asked by a judge if he had any words prior to sentencing. His crime was ploughing his ancestral lands after Pākehā illegally confiscated them. I have done no wrong. I have no blood on my hands, only the earth of my ancestors. I have no faith in your system. Do with me as you will. He was sent to Te Waipounamu and put to hard labour and imprisoned, as were hundreds of our people. 146 years later, nothing has changed. Our people have no faith in your system. Perhaps it is indeed time to step off. Perhaps it's time to step off this carousel of lunacy and re-establish our own judiciary. Tohu Kākahi predicted this. E kore e piri teuku ki te rino ka whitingia e te rā kangahoro ki ha. Te whiti o rongo mai predicted this. Nau te pāhua tuatahi maku te pāhua whakamutunga. Here we are the experts on colonisation. We see it every day. We've experienced it firsthand for generations. This bill is nothing more than a racist political move to manufacture consent for further state action against our people. I haven't even mentioned UNDRIP. Here we reject this bulletin in its entirety. Ngā mihi, kati.
Kia ora, thank you for that, Rory. We do have time for a question, and I see Steve Abel has a question.
Kia ora, Rawari. Accept your submission in its totality. It's very powerful. Thank you. I particularly appreciated your line in point 4 where you said the focus on vague principles ignores the fact that a genuine partnership requires real justice and acknowledging and actively addressing these historical wrongs, not simply defining abstract principles devoid of practical application or redress for the ongoing impacts of these injustices. Can you speak to the broader implications of us failing to treat te tiriti as a living relationship?
The ongoing
failure to treat te tiriti as a living relationship.
Yeah, well, it'll be the ongoing death of our people in the health system, the ongoing homelessness of our people, the ongoing poverty of our people, this cycle that maintains us in a space where we're unable to stand up without permission, without resources, because all of our resources have been removed from us. It'll just continue. It's the only role, the only job of a colonial government is to maintain tangata whenua in a perpetual state of dysfunction so that they can continue with their agenda of selling our resources and of making money off our backs. Aroha mai.
Kia ora.
Kia ora, Rory. Thank you for your submission. We're out of time, so we'll leave it there.
Kia ora, Rory.
Kia ora. Ngā mihi.
Hai, tēnā koutou.
Members, our next submitter is Mana Moana. We have them for 10 minutes. We almost had your camera on there. Oh, kia ora. Good to see you. Welcome to this Justice Select Committee, and thank you for your written submission, which we have in front of us. We've got you for 10 minutes, so I'll hand straight over to you. There may be questions at the end. Kia ora.
Are we on now? Is Te Vita Kaeli in the... Have they put Te Vita Kaeli in? He is starting us off.
We haven't got Te Vita online at the moment.
He's here.
Okay.
You're right. To Te Vita Kaeli, you have to accept the invitation to speak to the committee.
Right, so he needs to accept the panelist prompt. Just click on accept. When the prompt comes up, and he will be promoted to become a panelist.
Has he accepted it?
There
he is.
To be coming on now.
Yes, thank you.
Right. So if he can just switch his kia ora Te Vita.
Kia ora.
We've got you here. We're kind of pressed for time, so welcome to the committee. You've got 10 minutes. I'll just hand straight over to you. Kia ora.
Okay. Thank you. Tapu mo tangata I whanua a Aotearoa, mo te ika Maui, mo te Waiponam, kanaka o iwi o Hawaii, pepe ke tangata I whanua o Moana Nui, pepe ke komiti o e whakamau totonu. I begin with an honorific salutation to the tangata whenua a Aotearoa, te ika Maui, mo te Waiponam, also the kanaka o iwi o Hawaii where I'm located, and all the indigenous people of Moana Nui, and to the esteemed members of the Justice Committee. Today I speak as a Tongan, an indigenous person from Moana Nui, Oceania, and a relative to all Maori through our ancestors Tangaloa, Hina, and Maui. I'm also married to Elizabeth Rego Kaili, who is Ngati Hine and Ngā Puhi, and I express my deep aroha from Hawaii to Ngāti Hine and my Ngāpuhi relatives. I'm currently residing in Oahu, Hawaii, and I'm a professor of anthropology and cultural sustainability at the Brigham Young University in Hawaii. Dr. Nuhisifa Seve, Niwen, and I are representing the Mana Moana, We Are Maui, a collective of scholars, activists, and direct descendants of the Moana Nui region. These scholars and activists include Tina Ngata, Maori, Ngati Porou, Professor Vicente Diaz, Carolinian, Pompeian, and Keala Kelly, Native Hawaiian, Professor Kualoha Ho'omanawa Nui, Native Hawaiian, Professor Tina Taitano Telayo, Chamorro, and Brian Kafakafa Dawson, Irish American. The treaty principles bills represent a profound disruption to the intricate relations that have long defined Maori Tinoranga Tiratanga and the vast social ties that bind Aotearoa New Zealand to the broader Moana Nui region. As a collective, we strongly oppose this bill, which marked not a step forward, but a dangerous unraveling of Indigenous sovereignty, justice, and ecological responsibility. At its core, the bill weakens the Crown's obligation to Maori, disregarding the sacred commitments of the Te Riti o Waitangi and undermining the self-determination of Tangata Whenua. Rather than nurturing the va between Maori and the state, it had imposed an asymmetrical power structure that privileges colonial governance over Indigenous autonomy. This is not the trajectory of decolonization. It is a deliberate move to weaken Maori governance and entrench historical injustices. Beyond Aotearoa New Zealand, the implications extend across Moana Nui. New Zealand's colonial entanglements with Tokelau, Niue, the Cook Islands, and Samoa are deeply woven into the region's social-political fabric. By failing to uphold the Te Tiriti, this bill signals to the wider Moana Nui that Aotearoa New Zealand remains unwilling to reckon with its colonial past and present. The va between Moana Nui nations, built on kinship, reciprocity, and shared struggles, is placed at risk when Indigenous rights are diminished in one part of Oceania. The bill also threatens the ecological integrity of Moana Nui. Maori and Moana Nui people are genealogically tied to the land and sea, bound through whakapapa or hohoko to the sacred ancestral beings of the natural world. This is not a mere connection, it is an ontological reality. The va between people and environment is one of reciprocal care. Maori governance over marine ecosystems and climate justice efforts are integral to the protecting these ancestral relations. The weakening of Indigenous governance, as outlined in the bill, severs this relational responsibility and endangers ecological future of Moana Nui. Furthermore, the bill mirrors a broader pattern in Aotearoa New Zealand's foreign relation, a persisting privileging of strategic and economic interests over Indigenous-led governance. A future center on Te Tiriti would not only honor Maori rights, but also position Aotearoa as a leader in Indigenous-led ecological and political framework. Such a future would restore and strengthen the va within Moana Nui rather than further erode it. Ultimately, this bill is a stark manifestation of reluctance to dismantle colonial foundation. It does not foster tauhiwa, nurturing just and balanced social-cultural ties, but instead exacerbate the disjunction of power that have long marginalized Indigenous people. At this time, I'm turning over to Dr. Nuhisifa Seves.
Whakalofalahi atu, I'm speaking as a Niuean, born in Niue but raised in New Zealand. There are 5 generations of my mangawhaoa born in New Zealand. Relationships is a fundamental Moana Nui value. It underpins our experiences here as the Moana Nui diaspora. Our ancestors from the Moana Nui has always heeded the call of New Zealand. When you needed reinforcements for the New Zealand Expeditionary Forces during World War I, we came from across the Moana to join a war effort that our ancestors never really understood. They died and are buried across the oceans in the land of the empire and absent in the narratives of war of the empire. We heeded the call for labor. Our ancestors left their homes in Niue, Samoa, Tokelau, and the Cook Islands in the first migration wave of the late 1950s and 1960s seeking better lives. Tongans would arrive later in the second wave from the 1970s onwards. When we came, New Zealand simply appended us to Māori, and as such, we were subjected to the benevolence of the state. What impacts on tangata whenua will also impact us. This is what our experiences of New Zealand has taught us as descendants of our ancestors that came, never to return to their island homes. Our ancestors' pito are buried in the whenua of our island homes, but they rest here in the whenua of Aotearoa. The vibe between Moana Nui nations built on kinship, reciprocity, and shared struggles is why we are here today. We reject the treaty principle bill in its entirety. The integrity of Te Tiriti o Waitangi must be upheld to protect Māori rights, fortify Moana Nui solidarities, and ensure an Indigenous-centred approach to climate action. Only through such a commitment can Aotearoa truly sustain the vibe that binds land, ocean, and people, as our ancestors have done for generations. Whakaoelahi te tina ngata for writing the submission on our behalf, and the Mana Moana Collective, We Are Maui, We Are Moana, who continue to work across the Moana on issues of social justice and Indigenous sovereignty for the peoples of the Moana Nui. Whakaoelahi for the opportunity to present today.
Well, thank you very much for your submission. We're pretty much out of time, but thank you for that. And we do have your written submission in front of us as well. So, malo lele. Thank you.
Thank you.
Members, our next submitter is Te Karawai o Ngā Ruahine Trust. Kia ora, good to see you there. Welcome to this subcommittee. We've got you for 10 minutes to submit on the principles of the Treaty of Waitangi Bill, and we've got our written submission in front of us. So I'll hand straight over to you. Kia ora.
Anga mihi o te ata mōrena, katoia koutou te rongo? Rāwe. Ngā mihi o te ata mōrena ki a koutou o tino tātou katoa I tēnei rangi hira ara te rangi tua pā o te batatini ki waina I a mātou o te kāpui maunga. Mātou anō o ngā rua ine, no reira nei rā ngā mihi atu ki a koutou ngā mema o tēnei komiti. Kei te rangatira E Duncan o tino ki a tātou katoa ata Māori. Anei mātou ngā whakakano I o te korowai o ngā rua ine, ara te pau whakarai a Ima Gardner, maurata I korere noa rangi a pau. Ngā tarati. Ko mātou nei e waha ake e tuana kia wakapuaki I tā mātou waka ki te principles of the Treaty of Waitangi Bill. Ki mohio mai nei koutou nā te papaku o te wā nā ko nei ahau e mea ana ko te pire. Aha ko te whakaaro o te pire nei hei paina ki tā te titiro e te I. Ki ai mātou e wakai ana I ngā uatanga ka pākirunga I te motu wānui, wai o ki mātou ngai ri Māori, o tinoa ngā ononga anamati ki Wainganui I ngai Māori me te karauna. Ko te tiriti o Waitangi he kawenata. He kawenata rangatira I Wainganui I te karauna me ngā iwi Māori. Kaore e taia e te karauna anake te wakatakoto I te tikanga me ngā kaupapa tiriti ai wāngai hei wainga anora mō ngā iwi katoa. Ko te pire nei e pehi ana I ngā kupu, I ngā rangahau, I ngā whakaaro, no ngā kāwanatanga me ngā kōti o mua no nai nei uki. He maa o ki ngā tiro anga ki tō tēnā iwi, ki tō tēnā iwi, kia āhei pai ai rātou o tinoa tātou, ki tō mātou mana Māori motu ake. Nā te pire nei, ka pāngia mai te iwi Māori e te pokangā ture, me te toku waka mā I te mea kei reira e kōmingo ana, te kore mo iotanga I ngā tikanga tiriti. Mā reira anō, ka tupu, ka ua mai, te taonga a David Seymour ki Aotearoa, ara ko te whakawelu e me te rangirua. Nā reira, kaore e taia e te korowai o ngā rua ine, te waka ai, te tautoko rānei I te waka takotoranga pēnei. Ko te mana o tō mātou iwi, ko te tinoranga tiratanga me ngā tikanga o ngā rua ine me ona apu. Kei roto I ngā tukuwi hotanga e arahina mātou, te taia e te karauna te waka takoto tikanga ki runga ki a hau o ngā rua hine, o tinoa ngā iwi o te ao Māori katoa. Waiuri mai te waka tūnga mai o te tai piunara, I roto I ngā tau e hia nei, kua maride katoa tō tātou nei noho ngātahi, whakawhiti ngā kōrero, ki wainga nui I te kāwanatanga. Ia te wā, kua runanga ai ki tētahi wāhi aumaru, ka taia te waha ake I ngā wakatau o te iwi me ngā apu o ngā rua ine. I tēnei wā tonu, kua kōkiri tōnua ai koutou ki ngā tūkanga, ko waka aitia e maungatahi I roto I tō mātou krene. Ahakoa, ko koe tēnā e wati ture, e taka I tikanga o ki ka pupuri ana mātou ki o mātou, ake wakapono ki o mātou mātua tūpuna, me ngā arama a kua taka ia e rātou, ai wai ngā rangatira mo mātou. Nei e tūturu ana koutou ki te tumanapu kia oe ngāta I ai tātou o Aotearoa, I raro I te maru o tēnei pire, tēnā me piri me tata I mua rawa I tō eke ngai te waka. I nāia tonu nei, ko koe me tō waka ki tai, ko au, mātou ko tōku iwi ki uta. Kei te marama pū mātou ngā iri o tiroa ngā tāngata katoa Aotearoa ki ngā tāmitanga keiriro nei ia mātou nei kako kiri ake tēnei pire. Nā te kāwanatanga ānake rānei e nei wakaaro, nā te kāwanatanga ānake e nei kupu. A kua ngā taunaki maa ko wāriki ia I kite, I rongo, I kaute mātou, I ngā pōti waka ai ki tēnei pire I tōna pānuitanga tuataki. Kia matāra mai. Ka ore e kore, kei patu koutou te unga waka ai, he wakama. Wa ara ngā reo taika o te motu, kei tuku tautoko tonu mātou o ngā rua hine I tō mātou tino waka e ki te pire nei.
Tēnā anō tātou, kei te kōmiti e wakarongo pī kari maina. E rua ngā kaupapa kei te takere o tēnei waka. Ka timata te kaupapa tuatari, arā, ko te aumitana. Kei wainga ia mātou o te korowai o ngā rua ine, arā, me koutou o te kāwana. Ka tiki ake au I te kōrero a te minete amua, arā, ko Chris Finlayson. Nāna tēnei kōrero kia mātou te kautau ki muri. I te whakapāatanga te kāwana Moana mai I tūkino I roto I ngā taupapa ure ake. E pēnei ana, I roto I te reo Pāke atonu. The Crown hopes that this settlement and this apology will relieve the burden of grievance that Ngā Rua Ine has carried for so many years and will assist Ngā Rua Ine to heal the wounds of the past. The Crown looks forward to building a relationship of mutual trust and cooperation with Ngā Rua Ine founded on respect for the Treaty of Waitangi and its principles. E wāma, ka tuia he nei kupu I roto I te ture. Ko whakature hia, e rangi anō ia, me pēmea mātou wakapono atu ai ki e nei kupu. Te koutou noi o te pāake o tēnei wakatau, arā, kei te taka I te kāwana I tāna anō oati, I tāna anō wakapaa, I tāna anō ture, I āna anō kupu. Koa e mea ana tēnei pire, ka tiakina tonu tia ngā mōtika, te mana waka aere, o ngā iwi pēnei ia mātou, o te korowai o ngā rua ine, ko tā mātou e ki tō tikara wā atu nei, kei te e tēra. Nei ka rā weke ia, ngā mātou pono o te tiriti o Waitangi, ma mātou e ki atu, e rā weke o ki tērā I ngā wenu, I ngā wiri, I tui ai, te korowai o ngā rua ine. E ngā uewe, e wiri tērā I te tuapapa, I tuai mātou. I timata uki ai, tā mātou wakarauora, I a mātou anu. No e arawa mātou e wakai ki tēnei pere. E tino horera wātu nei. Nā, ko te kaupapa tuarua, e wete māku. Nā, ko tēnei mea te mana orite. E kōrero ana I roto I te pire mā tāpono te tiriti. Kāore kore kua nui no atu ngā kōrero mo tēnei mā tāpono. Me te paiuki o te mā tāpono, te mana orite. E o tiano me titira waka muri e ai waka mua, te tai pai atu ki te pai tapiti o mana orite. No te mea e māma noi o te tiki ake ngā tauira e ia ke maira o te ture tonu no roto I ngā tau I tuia ai patu I a mātou. Arā, kāre kore, korongo rā koutou I era mongo ture. Kāre kore, korongo rā koutou Ira I te Suppression of Rebellion Act, koira I āhei ai, te muru, te raupatu, te tai miriona eka I roto I a taranaki. Arā ko te Māori Prisoners Act, I āhei ai te mau ere ngā tupuna I no wai, pariaka, ahakoa te korenga o rātau I wakaangia e ngā kōti. Arā uki te West Coast Settlement Reserve Act, the Public Works Act, arā te mea. Aira ko te mana orite te waina. E rangi anō ia ko te kaupei, ko te tāmi, ko te muri me te raupatu. Tā ngā rua ine iwi I whiako ai. I roto I ngā rautau nei. Nō reira, e māminga tēnei kaupapa. E māminga no. Me pēwea mātou wakapono atu ai, ka manaori te Māori, me te Pāke a ki tā te ture titiro. No te mea, kāri pērā, I roto I ngā rautau kāri te pērā I ngā e tonu nei. Nei, ko te pēne tonu I tui ai, I au e ture. E uki tērā, e toki kē tērā, I ai pū, I te puku o te wenu. No reira, tēnei mātou te korowai o ngā rua ine, e taunu nei, e tātā nei, I te papaku o te ngā wakaaro I tūai te pire nei. I te kiko kore o ngā wakaaro, I potai tēnei pire nei ki te ao mārama. Ko tā mātou e mea atu nei, me oki tōtika atu tēnei pire, ki te pō, ki reira, waka ngaro atu. No te anō rā, koira tā mātou. Tēnā koutou kei te kōmiti. Ko te hoa, e rongo nei koutou. Ko te mai nui kei runga I au koutou nā poko iwi. No reira, kia kaa, kia māia, ana, kia tika. Tēnā tātou. Ohi ki nāke.
Ngā mihi, thank you for your submission. We've got a little bit of time and I see we've got some questions. Let's go to Takatu Ferris.
Kei ngā uri o te maunga tēnā rā koutou. Ko tā tātou e ki te atu nei, ko te mauroa o te wairua raupatu o te kāwanatanga. Tā tātou e marama nei, ko tō tātou mauroa ki te ngākau pai o tō tātou iwi. Engari te ahua nei kāore te iwi Pākehā me tōna kāwana mo te tahuri mai ki tērā wairua manaki o te iwi Māori. No reira, tēnā pēr hika makua taipē ki te wā kia hikina tō tātou whakae ki te tiriti o Waitangi. Kia wai ho te kāwanatanga tā rewa ai, whai mana kore ai, tana tū I roto o te aroa, pē o koutou whakaro ki tērā.
Ahua, he wakaro hou, hara I te hou engari, ai, he tika me wānanga hia I taua wakaro.
Tika.
Ko tā mātou te korowai ahua aro ana kia mātou anō me te ara tika, ko ahua aukatingia te kāwana me o rātou ture. Kua kaore anō kua wakai ko tēnei te wakatauranga o mātou o te korowai, kua ahua a te whai taua ara, ke tia. Nā te kōrero Māori ki te kāwana, nā te tiro kia mātou anō mō ngā rongoa, mō ngā wakautu, mō ngā hara kua puta I ngā tau kua paure, pērā I te muru me te raupatu he hāke. No reira, te pātai whai tērā.
Kia ora, thank you. I don't mean to cut you off, but we are pretty much over time now. So thank you for the submission and the answer there. So ngā mihi and ka kite. See you later.
Tēnā koutou. Tēnā koutou.
And members, our next submitter is Toitu Whangaroa. Kia ora, good to see you there. We've got you for just 5 minutes and we've got your submission in front of us, so I'll just hand straight over to you. Kia ora.
Greetings and salutations from Whaingaroa Raglan. We are members of Toitu Whaingaroa and collectively hold expertise across community-led development, local government, education and research spaces. We're in total opposition to this bill. We will take our submission as read. All the reasons we gave in our opposition to the bill have over the past weeks been so eloquently spoken to, and there is nothing further we can add to those arguments. What we would like to focus our time on is what happens after this bill. Yes, there are assurances this bill will not proceed any further. However, this situation has illuminated the significant gaps which exist in our knowledge regarding the constitutional foundations of our country. Ensuring we never end up in such a divisive and collectively damaging situation again, we must be a common priority as we move forward as our nation beyond this bill. Toitu Whaingaroa focuses on growing community capacity to realise the founding partnership relationship which was aspired to in Te Tiriti o Waitangi. Two tupuna of mine were signatories to Te Tiriti o Waitangi. This includes Te Waitaia, whose vision was always that all peoples flourished alongside each other as envisaged in Te Tiriti o Waitangi. In January 2024, after returning from the Hui Amotu at Turanga Waiwai, we knew we had to organise a Waitangi Day at the call from Kingi to Heitia to bring our community together to recognise Te Tiriti o Waitangi.
In 2024, we invited our community to come together on February the 6th at our town hall. The walls of the hall were lined with historical and contemporary Te Tiriti timelines, crown breaches and Māori resistance, handwritten on brown paper. There were key quotes from the Hui Amotu on display boards and also the live feed from Waitangi. There were comfy places for people to sit and reflect, to chat with others, to browse through resources, and to sign up to learn more. There was the 10-foot Toitu Te Tiriti Whaingaroa canvas that people could sign their commitment to, and a space to create flags for our community Kotahitanga Kurawai. Then, due to the community requests that followed, we displayed a smaller version of the Waitangi Day exhibition in a local exhibition space. People who visited that display then requested if we could bring the display to their groups, so we did that, creating a travelling 1.5-hour workshop which has been delivered to a diverse range of audiences, including local teachers, senior drama students, Waikato Catholic Kahui Ako, Raglan Radio and Avira Schools staff. We held another Waitangi Day event this year, and before the day had ended, we received further enthusiastic feedback from the community on what we could include for Waitangi Day 2026.
The ability to have this bill into Parliament relies on people, including our elected representatives, having no knowledge of the constitutional foundations of our country, nor any understanding of how these foundations in reality provide the basis of a flourishing future for all in Aotearoa. This bill has brought that knowledge gap sharply into focus. This bill talks about a national conversation about Te Tiriti and to have voices from across Aotearoa participate in that kōrero. Imagine the quality, richness and depth we would have achieved if that kōrero came from an informed place. Imagine the conversations we could have and the dreams we could realise as a nation when we understand not only our past, but how Te Tiriti lays the pathway for our collective flourishing futures in Aotearoa. We finish our oral submission by highlighting the final recommendation in our written submission that priority is given to investing in the provision of nationwide Te Tiriti education. The oral submissions over these past 3 weeks are themselves a priceless and accessible teaching resource for all of Aotearoa. Over the space of a year, we have reached over 1,500 people with our mahi just in our small community. From this, we know that realising Kingi to Heitia's vision for kotahitanga in Aotearoa is entirely possible. Nationhood, cohesiveness and unity is grown when we have well-informed communities. Toitu Te Tiriti.
Toitu Te Tiriti.
Kia ora.
Kia ora.
Kia ora. Thank you for your submission. We are out of time, so Steve, we haven't got time for your question. But thanks for your submission, and thank you also for your written submission and the work that you do. So,
Yeah, thank you.
Kia ora.
Kia ora.
Kia ora.
members, our next submitter is Marama Fox. We have Marama for 10 minutes. Kia ora, Marama, good to see you. Thank you for coming to this subcommittee. We've got your submission in front of us and we've got you for 10 minutes, so I'll hand straight over to you. Kia ora.
Kia ora, Duncan. I'm here with Tamaiti, who was unable to make his submission yesterday. He's been here at Te Matatini, and so I'm going to give 5 minutes of my submission to him today.
Kia ora tātou e hoa maa. te tino pūtake o tēnei o aku kōrero I tēnei ata. I te rono ake I nā whakawhiutana o tēnei pire ki runa I a mātau. O te āhuatana koa pōrearea, he whakapōrearea I te āhuatana o te huarahi. Koa, I runa I taku mōhio, ko tureke te pire e mōhio ana tātou. Ka hara mai tētahi tanata, no nanahi nei no aia. Kare e kite I nā hikoetana, I nā āhuatana I whiriwhiri hia ki te āhuatana ana te mea. He maha te huna nā rātai mahi, I roto I nā rima te kautau e mōhio ana hau. Ko hau anō tētahi o tanatara. E maha mātau koene, no reira kai te kiri wasi katau ki tēnei momo āhuatana, no he hoki tēnei tanata. Ko te mateke, kōtau e te ture, te kāwana tana, I tako pōhehe, kai te haumaru hia tēnei ture, ke korai tētahi maki e kuhu mai ki nune te whakapōreare I tēnei āhuatana. No hea tēnei momo āhuatana. Mena, he hoki nā nei nā, ki nā whakawhiwhiruna, me pēnei pēr te kōrero, he aha te huarahi. E kene pēr, me kōrero ke mai a tātou. Ke kōrero mai aia ki a tātou, kanohi ki te kanohi tanata ki te tanata. Tēnā hea rawa te tūmanako, te whakaaro, I hohou mai ai tēnā whakaaro I roto I aia, ka kuhu mai I kuneina, ki te rānaki nā kaupapa I tako pōhehe, ko tapuke nei ture, ai here I a tātou, a pāke hama, a rāwaho I a tātou I te hau kāina. Koe nini hou aku nā me, nei pēr te pātai ki aia, tēnā pēr me whakawhiti kōrero he aha te huarahi e tikana nei nā, ke ātano tātai I mua I tōna whakawhāriki ki tēnei pire ki mua I tō tātou nā aroaro. Koe nini hou aku nā kōrero e hoa ma, hoa no I karau I wātea, I naro au I nana he nei rā, hoa nei hara mai konei ki te tuku etahi nā pita kōrero ki mua I a kōta, anei ki te tahau ki tako hoa, tuahine nei ki a marama. Kia ora kōtau.
Pai, kia ora, thank you. Kia ora. I think you have my submission. Basically, this is just mischief making by the government to first allow this bill to come before us and this expensive waste of time that we are even debating this. The principles of the treaty is because we couldn't adhere to the letter of the law of the treaty under international law of contra preferentum. And we've been doing this for such a long time now. And we want to talk about, the government talks about equal opportunity. Equal opportunity, we'd love that. That'd be great. They talk about privilege. We'd love that. That'd be great. They talk about not wanting equitable outcomes. Well, we've had the evidence of that for over 150, 180 odd years. When the treaty has been breached, the equitable outcomes do not happen for our people. When the treaty continues to be breached, we land at the bottom of all the statistics that this government has tried to implement through all of their measures. And if they were going to work, they would have worked by now. Basically, it's just playing and mischief making with our people and with this country. And we oppose it out of hand, take it off the plate, and stop messing around with all of the treaty clauses and every other piece of legislation. This government is still obligated, whether or not they take those clauses out of these pieces of legislation that we fought so hard to put them in, to uphold te tiriti as it is, as it was, and as it continues. Toi tu te tiriti, kaya koutou te wā.
Ka pai, thank you, Marama. We've got some time for questions, and I see Steve Abel has a question.
Kia ora, Koroa. Thank you both very much. Do you think that this bill has become a smokescreen for all those other bills that are undermining and attempting to dismantle te tiriti?
I'll start. Yes.
Yeah.
It's a complete smokescreen. It's just mischief making with the country while they continue to rip out the parts that the treaty has played in all the pieces of legislation to try and create equity and address the injustices when the treaty has been breached.
Dr. Fury.
O tēnā kōrua, te pāpai tame, kōrua tai, marama. Kōrua, we've been doing this for so long. To arrive here at 20 2025 and be confronted with such an affront on everything that's been done, as you two have described. What do you think? What type of action do we need to take here? Tiwi Māori?
I think we've gone beyond that, you know, and we just continue to have those voices out there and to resist anything that come in front of us. If it's just hoa, you know, it's a game of chess, you know, and they're playing chess on us and checkmates, you know, and kuretaki, you know, kare una raho I tēnā āhuatana. Koe rā te whakaaro, nari me kimi, kai te mūhia ko rua tātou whakahuihui ana ia tātou katoa. Tangata tiriti, I wahu atu ki tērā, we had to move on. I too had to move on. In the pioneering the pathway that enable us to haere ki te taumata tika.
You know, I just want to say on top of that, thank you, Papa, is that Tariana established whānau ora with the national government because they saw that this was the way. Our whānau have the answers and have had the answers since the treaty was signed. The protest action has not stopped. Kohanga Reo was started legally. Kura Kaupapa Māori was started legally. And today we have the most successful kura in the country in Decile 1 regions that are not being promoted. Kaupapa Māori pathways are not being promoted as the pathway for success when our students have proven over and over again that they have outstripped all of the NCA achievements in this country, highest achieving kaupapa Māori models. We have the answers. We just need a government that has faith in us like they did in the past to continue to uphold our models of practice. When I look behind us and I see who's coming like we do on Te Matatini stage right now, have no fear for our future. Kaupapa Māori models of practice are the models that raise us out of the statistics that we have been bound to through constant breaches of the tiriti. And we need to have a government that has faith in us to be ourselves.
Kia ora,
Thank
kia ora,
you.
tēnā kōrua.
Yeah. Kia ora kōrua. Thank you for your submission and good to see you both here today. Kia kite.
Ngā mihi. Hei kona.
Members, the next submitter is Waikato Seeds for Change Charitable Trust, and we have them for 10 minutes. Kia ora, good to see you there. We've currently got you on mute, that's good. We've got your submission in front of us and we've got you for 10 minutes. So I'll hand straight over to you and there may be some time for questions at the end. Kia ora.
E mokopuna ahau no ngā te haua me ngā te koro ki kahikara.
Kia ora, Dujon coming forward here, long-time kaimahi in the rangatahi space in Waikato and performer and dancer of 25 years here and abroad, here to tautoko.
Ko mātou mahi kaimahi mātou ki Seed Waikato. Me e toru ngā mea ki o mātou whakapono. E toru ngā mea nui. I te tuatahi ko whakawhanaungatanga te mea nui. I te tuarua ko manaakitanga. Ko tēnei te tino whakapono kia mātou. I kaore tēnei pira e whakamana nā rangatahi, tai ao, me tai ohi hoki. He tino pauri ki te kitea te whakaiti o te mana o te tiriti o Waitangi. Kore kau ngā manaakitanga ki ngā mana whenua. Me I te tuatoru ko tahitanga. Ko tira te mea nui ki a mātou, me o mātou motu ko Aotearoa. He mahana nā tangata tiriti I haere mai ki konei kei Aotearoa. Kore kau nā ako-oranga o te tiriti o Waitangi I te haerenga o ngā tangata tiriti ki konei. Koenei he mahi tūturi ki o mātou mahi I te toatahi te tiriti o Waitangi. Nō reira, ke konei mātou ki te kōrero mo te whakamana o tēnei pira o o Te Tiriti o Waitangi. Ko o mātou whakatauki, ko poipoia te kakano kia puawai, me kaore tēnei pira I poipoia ngā kakano, ngā rangatahi, ngā tai, te tai ao. Ai, kia ora. Over 2 times.
Kia ora. Tēnā tātou katoa. My voorouders is van Suid-Afrika en die Nederlands. Die berg of Moana wat met my hart praat, is die Drakensberg. Die rivier of Awa wat my bekommernisse verlig, is die Amgani. Ek is in Durban groot geword, ek woon nou in Kirikiriroa. Maar my tūranga waiwai is Whaingaroa. Ko Tanya Poynton toko ingoa, ko au kai whakahaere o Seed Waikato. As leader of Seed Waikato, we take our submission as read, but we'd like to share a few extra things with you today. Today, I stand here as Tanga Te Tiriti, and I'd like to share my personal story. Like almost 1.5 million others, I've had the privilege of making Aotearoa my home, and Te Tiriti o Waitangi has given me this opportunity. Instead of wasting time, energy, and money on this narrow-minded bill, instead we should be investing it in fit-for-purpose Te Tiriti training for every single person settling in Aotearoa. Ironically, this treaty principle bill has shone a light on a glaringly obvious gap. It's only been in the last 18 months, with the Crown's blatant attack on Māori rights, that I've come to the realization that I could have been a better treaty partner 25 years ago. I had absolutely no idea of the context and even what the treaty meant. It should be a minimum standard that every person coming to live in this incredible country understands the full context and what has happened over the past 185 years. We have 30% of our population that may not even understand that they are treaty partners too under the Crown. I urge this Select Committee to recommend we create a system where every person settling here has the right and proper access to treaty training, meeting them where they're at. It should be a minimum standard. Now's the time to show future generations that we stand by our word and honour the true intention of Te Tiriti o Waitangi, because there's space for all of us. Anything less is a failure of leadership. We now have a little enactment in true rangatahi fashion. We'd like to make special mihi and acknowledgement to E Tangata for their content and giving us the creative inspiration to share this small piece. Let's see if you can see the analogy. Imagine if you were someone living in a house that you inherited. You were living in a way that worked for you. But then someone came along and asked if they could be your flatmate. You thought the arrangement could be cool for both of you and your flatty, so you make a flatmates agreement. But when your flatmate moves in, they start to move all your stuff out to make space for their things. They start making house rules without your input or considering your previous routines. They even begin to denigrate you so badly that you begin to lose confidence in yourself and lose your self-esteem. What's more, your flatmate tells everyone else how amazing they are to you and how they've made your flat look so much better. It gets even crazier when you share your side of the story and your flatmate finds this very difficult to hear.
They genuinely surprised when you describe the inequality of the relationship. How can we even begin to think this relationship is equal and that it's built on any worthy foundation? It's time to level things up and honour Te Tiriti o Waitangi. Thank you.
Hikoi in the streets, you can hear the haka roar. Rangatahi rising, we ain't silent anymore. No more bad deals, no more settler spin. Take that bull and throw it in the bin. Word.
Kia ora.
Thank you.
Kia ora. I don't think we've had a drama submission before, so thank you for that first. Possibly in the whole of the New Zealand Parliament, but very, very nice, very well portrayed. Thank you very much. Members, we've got a minute or two for questions, or a minute if anyone has one. Steve?
Yeah, that was fantastic. More of that. And the last bit you spoke about actually in your waiata is about the rising of young people in defence of te tiriti, both tangata whenua and tangata tiriti. And does that give you heart that despite this, gross attempt at erasure, that there's going to be an ongoing movement that will see te tiriti fulfilled?
Tika, I think it's going to be an ongoing haerenga, but I think from a lot of the kōrero that we've been a part of in the community, we know that there are some things on the rise. It's been also really awesome to hear and see the mahi of Te Pāti Māori with Hana Rāwhiti and the Mokopuna generation coming through as well. And so just seeing the Kura Kaupapa generation is super inspirational and inspiring, seeing them live with their reo and haka and kind of reclaim and revitalise our reo is really powerful.
Thank you. We've got a question from Takata.
Kia ora koutou. Hey, awesome approach. And your point that you make that the glaring, the elephant in the country is that not enough people know or understand anything about it. So your point, thank you for making the point again. I think it's a point that the committee now cannot ignore as we move towards making the report and its recommendations. So no part, just saying thank you very much for your time and awesome. Keep going with the educational work out there. Tell all your mates, do more skits like that, and kia kaha tātou.
Kia ora.
Kia ora.
Thank you for that. That's pretty much at time now, so thank you very much for a refreshing submission. Ka kite.
Ka kite.
Members, our next submitter is Rosie 5. So we're just skipping over 1 and going to Rosie 5. And we have Rosie for 5 minutes.
Sure. Koto, thank you so much for all your work. I really appreciate all your listening, and it's a privilege to be here. So my name is Rosie Fife. I'm fifth generation New Zealander. My first ancestor arrived here in 1841. So just after the treaty, so they were tangata tiriti as I am too. I'm a deacon in the Anglican Church, hence the fancy dress today. And I'm also the National Director of NZCMS, which is the New Zealand Church Missionary Society. So obviously CMS missionaries had a lot to do with the original Te Tiriti. So as an organisation, we are very passionate. We have partnerships with the Māori Anglican Church, and we seek to honour the Te Tiriti in our work now. And as an organisation, CMS has had so much to do with the founding, and I don't need to give you a history lesson, but the role of James Stephen back in the UK, who came out of the same movement as CMS, the translation, and also the fact that Rangatira signed, partly because of the trust they had of the CMS missionaries. I won't talk a lot, but I will just say that I think the understanding of Te Tiriti as a covenant is really important. It's not a contract that ends, it's a relationship that continues. It's based on relationship and trust. I'm reasonably new back in New Zealand. I've lived overseas, but the work of Alistair Rees and Hamish McLean has really shaped my understanding as a Christian in this land and my role as director of CMS. And really interesting to think about some of the first translated words of the Bible in in Aotearoa into English and into written Māori. And it's actually the role of scriptural and understanding of the rangatira. There's some quotes around how they understood covenant actually fundamentally in the Bible and how they translated that into tiriti. I don't think we talk about that lots in a mainstream context. So really that understanding of treaty as covenant, and also it's pretty obvious that treaties between two parties, so one party can't change it. I want to share briefly one story from this role. I've been in this role 5 years. I was privileged to go to Tauranga to take part in an apology that the Anglican Church did around some land that was given to CMS missionaries that was inappropriately used and sold, and then another hui on restorative justice. And sometimes I wish every New Zealander, every citizen could come and be part of that, because I had such a deep sense of the role of te tiriti for tangata whenua, particularly as they came up in shares, and what restorative justice or a measure of restorative justice could look like in this land. So I would ask that this bill be dismissed. I'm actually really saddened by division that this bill has already caused, and I hope that we can continue together in a fruitful way in Aotearoa, New Zealand. Thank you so much.
Kia ora, thank you for that. We've got a question from Steve Ablin.
Kia ora, thank you so much. I have been reflecting a lot myself on the idea of treaty as covenant, and that it seems that tangata whenua have always held the treaty as sacrosanct, whereas when it's left to the care of tangata tiriti, it ends up sort of mouldering in a basement in Wellington, damp and gnawed at by rats, you know.
Indeed.
And that what we need more than ever is for tangata tiriti to step up in defence of the treaty that is our constitutional foundation, because after all, I wonder if you can reflect on this, the real beneficiaries of te tiriti waitangi are tangata tiriti.
Yeah, absolutely. I think it's worth thinking about the two different understandings both parties brought to this. And actually, I'm a historian by background, so I think actually understanding what did it actually mean for those who signed it, what does that mean for us now? I mean, that's such a cool thing to reflect on. I mean, I think our nation is stronger when we all take part in that bicultural relationship. I think our organisation CMS is stronger when we work with our Māori partners. We have Māori evangelists in partnership, and that is such an amazing thing in our organisation. So I think you're right, it's not a scarcity mentality of we lose things. It's actually what could our country look like? What could our future look like? I've heard Justice Drew Williams at Moana a couple of years ago talk so passionately about what it would mean to be a country in the South Pacific that just lives out of that beauty of fullness of culture and relationship and trust. I think that's like an inspiring vision for the future. So I'd recommend this book to anyone.
Thank you for that, Rosie. We're at time, so we'll leave it there, but thanks for your submission. Thanks for coming online.
Thanks so much, Duncan, everyone. Thank you.
Members, our next submitter is the Legislation Design and Advisory Committee for 10 minutes.
Tēnā koutou katoa. Can you hear me?
Kia ora, we can hear you. We've got your name as Mark Steele.
Yes.
We can't see you yet, so if you want to put your camera on, you can. But otherwise, if you want to just do it audio, we can do that too. Oh, there you go. Kia ora, Mark. Good to see you. We've got you for 10 minutes, and obviously we've got your submission in front of us. I'll hand straight over to you. Kia ora.
Thank you, Dr. Webb. I'm Mark Steele. I'm the chair of the Legislation Design Advisory Committee. I'm joined today by one of my fellow LDAC committee members, Matthew Smith, who is a barrister. A brief word for the information of committee members who may not be familiar with the work of the Legislation Design Advisory Committee before we speak to the submission. The Legislation Design Advisory Committee is mandated by Cabinet to advise on the consistency of bills with what are called the legislation guidelines, which are also developed and published by the LDAC. And these bring together a whole range of legal and constitutional principles Our job is to focus not so much on the fundamental policy of bills, but on good legislative design, and especially the consistency of the proposals with the established principles of law and constitutional principles that are included in the legislation guidelines. There are about 20 of us on the committee all told. We are a mixture of public and private sector members who were appointed by the Attorney General. The Treaty Principles Bill for us raises three broad design issues, which we touch on in the submission. The first is fit with existing law and constitutional arrangements. The second is the very broad implications of these principles as they are stated in clauses 6 and 7 of this bill. And the third is the process that the LDAC think should be appropriate for the development of a bill with such wide-ranging constitutional significance. And I'll just speak briefly to each of those three issues. Firstly, there's already, as the committee is well aware, a large body of law, convention and practice regarding the treaty, which has been developed now by successive governments, the courts, the Waitangi Tribunal, over the last 50 years. And it's now reflected in New Zealand's common law, many statutes, treaty settlements, the cabinet manual, really throughout our government. The principles of this bill will, of course, affect that body of law and practice, but it will also be interpreted in the light of that body of law and practice. And it's quite unclear what the results will be in practice. The LDAC considers that it will be preferable to continue with the approach that we have used thus far and we're currently using, which is to tailor and develop law and convention about the treaty to the specific circumstances that we face, rather than trying to apply such a broad brush approach. That is the approach proposed by this bill. The second issue for us is that clauses 6 and 7 of this bill purport to control the effect of future legislation. This is both rare and constitutionally significant. Clause 6 also purports to limit the powers of Parliament and the Executive in a way which is significantly different from what is currently contained in the Constitution Act 1986. And this will lead through litigation to wide-ranging and unintended effects. The third broad point that we would like to draw attention to in our submission is that given the constitutional significance of this bill, the Legislation Design Advisory Committee would expect it to receive especially careful scrutiny and an extensive and inclusive process to be part of its development. In 2013, the report of the Constitutional Advisory Panel at that time made a number of helpful recommendations about the elements of such an approach. And the main ones are ample time, a non-partisan approach, participation which reflects both the treaty and New Zealand's demography, a comprehensive information campaign, and an exclusive and well-advertised set of opportunities for public participation. These are the kind of approaches that we used in the lead up to the Bill of Rights Act and in changes to our electoral system. They haven't been used here. And I think it's very important, given the wide implications of this bill, that a process along those lines is used. Thank you very much, Chair.
Thank you very much. We've got some time for questions, and I'm going to ask one myself, if I may. Obviously, the bill suggests a referendum on these issues. Quite apart from the kind of nature of the legislation, can you comment on the use of referenda for questions of constitutional importance in terms of a useful legislative tool?
LDAC, Chair, doesn't have a view on the use of referenda themselves. That's a matter for Parliament and governments of the day. What we would like to see before we get as far as a referenda are the kind of steps and the kind of process that the Constitutional Advisory Panel recommended and has been used for those other constitutionally significant changes. We think it's very important that the ground be prepared in that way. Whether then a referendum is held is a matter for Parliament and governments of the day.
All right. Go to Steve Abel, and we should have time for Takata as well if we could.
Kia ora, thank you, Mark. I wonder how exceptional in the sort of context of parliamentary processes or history is it for a government to allow such a flawed bill, as I would interpret it, with so many red flags, to make its way to first reading and then to select committee?
I'm afraid, Steve, I'm not a historian, so it's hard for me to answer that question. Part of the reason that governments use the Legislation Design Advisory Committee is as part of the process of subjecting bills to careful scrutiny. We would always recommend that bills go through a process of careful preparation before they get to the select committee stage. The select committee stage is a crucial part of scrutiny, but it's not the only part of legislation's development. And it's always a call for the existing government to make, of course, at what stage of development they decide to introduce a bill. But we recommend, and they're included in the legislation guidelines, the kind of steps that we're talking about now before you get to the select committee stage.
Takata?
Kia ora. Look, sort of in the similar vein as the other questions, my observation of Parliament is that it's actually not structured in a way that enables the voice of the treaty to be heard and then deliberated and considered well. And we could probably conclude that, after a long colonial history, that's probably not, that's probably, that's how it would be, of course. So there needs to be structural change. Do you have a sort of view around what type of structural change could be useful for making this type of conversation and this type of debate in the future a more quality conversation and debate?
The LDC doesn't have a view on the structural changes, but we do, as our submission says, have a view that a bill of the constitutional significance of this bill should work its way through the kinds of processes that I mentioned were recommended by the Constitutional Advisory Panel, and those have been used for other significant changes to our constitutional arrangements, like the Bill of Rights Act and changes to our electoral system. And we would expect those kinds of processes to be used for constitutionally significant legislation or legislative proposals.
Kia ora. Kia ora, thank you.
Is there time for another one, Mr. Chair?
Yep, go Steve.
You use the term careful preparation as a reference to what any bill of this substance should have undertook before it got to the House. This bill hasn't had that careful preparation, is essentially what you're saying.
This bill certainly doesn't appear to have used the kind of steps that we've just worked our way through in this conversation.
All right, thank you for that, and thank you for being religiously apolitical. Well done, not an easy task today. And thanks for all the wider work you do that largely goes unnoticed by the general public, but I'm familiar with the stuff you do around legislative equality, so thank you for that.
Thank you, Chair, and thank you for the opportunity to speak to the submission.
Thank you.
Members, the next submitter is Dennis Grinnell, and we've got Dennis for 5 minutes. Oh, okay. Sorry. Backing up. We've got Bhushan Patak. Bhushan for 5 minutes. So Bhushan, if you can hear me, we just need you to switch your audio and video on.
Hi, can you hear me?
I can hear you now. We can't see you, but we can proceed like this if you like.
I don't know why I can see you clearly.
That's right. There will be a video icon, but look, we can proceed audio. We've got you for 5 minutes, and we've got your submission in front of us. So we can just get straight into it, and you can speak to your submission now. So thanks very much.
Thank you for giving me the opportunity. And as you will see, I migrated from India almost about 20 years back, and I'm now a citizen of New Zealand. So my main submission and my main thoughts, I would say, as to the Waitangi was that I believe that every citizen should have equal rights. That is the underlying principle of all democracies and all constitutions all over the world. So as long as the equality is maintained for all citizens, then of course we have various ethnicities, various people from different countries who are all here to do what they do best. But under no circumstances should we have any legal system where you decide by ethnicity, you decide by somebody's walked in 5 years back or 20 years back, so he has more rights and we have less rights. So basically mine is equality for all citizens of New Zealand. That's the first part. And the second part is that we have to understand that in a democracy, it's the will of the people that decides everything. If the will of the people, if the majority of the people want a change, then there is no option but to go with the change. The parliament is supreme. And once I would even go to the extent of saying that if there are any disputes, the best way to resolve is a referendum. Have a referendum, find out what the people of the country want, and that's ultimately, that's going to be what it is. And you cannot always go by old documents, 200-year-old, 100-year-old. If you remember the British Parliament system, they once had a Magna Carta, which was the ultimate thing of how to run the government. But it's changed over the years. So I feel the only thing permanent in life is change. And you have to accept the change, and you have to accept what it is. So any other questions that you would like me to answer, or?
Yes, we have a question from Steve Abel.
Yes, please.
Kia ora, thank you for your submission. I wonder if you would agree that in a rights framework, which were sort of devised back from the days of the Magna Carta and before,
Yeah.
devised to protect people from the tyranny of power and from the tyranny of the majority. So
Absolutely.
by definition, certain rights, such as the rights of the children,
Mm.
only belong to some parts of the society, because we're not children, we're adults, we don't have rights of children.
Absolutely, sir.
And so those rights frameworks actually allow for things like the rights of people to practice minority religions and the rights of Indigenous people to have things like the founding agreement of Aotearoa New Zealand, which is Te Tiriti, upheld and honoured rather than undermined. Don't you think that is consistent with a rights framework and an idea of fair use of the law for all?
No, absolutely. I agree with you, sir, that it is the minorities have got to be protected and the rights have also got to be protected. But
Right.
sometimes, sorry,
No,
after
go
you.
ahead. No, sorry, I thought you'd finished.
Oh, no. So I say I totally agree that the minorities and the rights should be protected. But a law which was made 150, 200 years back, an agreement which is made to that, has to change with time. You cannot stick to just, I'm an Indian and I have migrated from India. And we also have very strong cultural and religious beliefs in India. which go back not 100, 200 years, thousands of years back. But slowly with time, slowly you got to realize that some practices which we are being followed are not good or are not beneficial, and they have to change, and the people have to change along with that.
All right.
Sorry.
Thank you, Bhushan. We haven't got time for another question. I apologise. We're out of time. But thank you for your submission, and thank you for your very brief written submission as well. Kia ora.
Okay. Thank you for giving me the opportunity to appear.
It's okay. All good. Our next submitter is Dennis Greenall. We have Dennis for 5 minutes as well. Kia ora, Dennis. Good to see you. Thanks for coming online. We've got you for 5 minutes to talk about the principles of the Treaty of Waitangi Bill. If we've got time, we may have questions. I'll hand straight over to you.
Kia ora rā. Mei tūtahi ki te kānohi mohi o tēnei. Kia koe tākuta kei te mihi. Ki era atu koutou o te komiti anei, anei rā te mihi kia koutou katoa. Greetings, everybody. I'm assuming that my submission has been read. I'd like to spend this time talking about the neoliberal agenda of this government, previous governments. It's seen the rise of racism in this country, the marginalisation of Indigenous people and minority groups. That can be recently evidenced by just the arrival of Destiny Church at the Child's Public Library reading in Auckland, and also the action of this government and the loss of hundreds, if not thousands, of Māori jobs across the public sector. Just a couple of statements I'd like to make. Tiriti o Waitangi cannot be rewritten. It was signed by two sovereign people. Māori never ceded sovereignty. Some people might say this is not so in terms of entering into treaty settlements. However, the return of less than 1%, which was immorally yet legally stolen from us, is hardly ceding sovereignty in my mind, and or possibly in the future minds of our next generations. Remembering that 50% of our population is under the age of 25. We have a huge young population. I'm from the first urban-born generation of Māori males. It's from my generation that the abuse and state care inquiry has come from. That has not finished. That continues today with Oranga Tamariki and what's happening there. This is really about my lived experience over this period of time, and my part in terms of treaty training across a number of sectors, including the government sector. I'd like to have a little look at the history of New Zealand, which is definitely his story, which is really riddled with lies and myths about Māori. One example, the Hun report of the 1960s, saying Māori were deficit of culture, and that was Pākehā culture, and we needed to get our schools into preschool. Māori never sent their kids to preschool. The myth and lie that came out about that, Māori aren't interested in our children, and Māori aren't interested in education, a myth that was blown apart, even though it still exists, by the establishment of Kohanga Reo Kura, Wharikura, Wānanga in the 80s. All of those brilliant Indigenous educational institutions have been curtailed, if not stopped, by previous governments. If we have a look at Aotearoa, it's certainly her story as opposed to his story. Her story of Papatūānuku, the abuse and rape since the arrival of Europeans in this land, right up to my biological mother, and the oppression that she suffered, being strapped at school for speaking her own language, being refused entry to places because she was Māori. My mother was part of the urban drift, which was a boom and then a bust. And with the bust came gangs and dependencies. That history, I'd like to quote a little term from Tina Ngata in her analysis of white feminism called coloniality, and the part that white women have had to play in the colonization of this country. So it'd be worth reading some of her stuff. Some of the main points I'd like to look back at, if we look around about the period of time that I entered into this earth in this particular life, in the late early 60s and 70s, if we go through to the 80s with this amount of time, I want to acknowledge Puao Tiatatu, a report that came out of the Ministry of Social Development, headed by John Rangiho, absolutely stating that the department was riddled, as with other state departments, with institutional racism and unbiased conscious or racist thinking. This has been proven through research time and time again since that time, but nothing has been done with it. Because the other thing that came out of the 80s was Rogernomics and the beginning, and that was a Labour government. So it doesn't matter what government's in power, the neoliberal agenda runs.
Dennis, I'm just going to let you know that you've got about 30 seconds left, so you need to just kind of wind up.
Okay, not inclusive of what you just said, I hope. So I'd just like to say that it works for multinationals, it works for elitists, it works for few, it works for virtually nobody. Māori Marsden's analysis of Te Tiriti o Waitangi was sovereignty, was a relationship's importance of that, was tohungatanga and expertise, was ukaipo, a place for everyone, but the parent vine was kotahitanga and unity between all of us. This government, previous governments, continue to divide by divide and rule. So why are Māori being attacked? Because the tiriti o Waitangi and Māori is what stands between the demise of humanity and the planet, basically.
Thank you, Dennis. We'll leave it there. We're well out of time, so we don't have time for questions. But thanks for your written submission, which we have, and for coming online today. Members, our next submitter is Te Pumutanga o Te Arawa. Here we go. Clark Purika. From there, once he's got his audio and camera on, we'll be off.
Kia ora, Duncan.
Kia ora, Clark. Good to see you. Thanks for coming online. We've got you for 10 minutes to speak on this Treaty of Waitangi Principles Bill. We might have some questions if we've got some time. I'll hand straight over to you. Ka pai?
What, can you see me and hear me okay?
Yes, we've got you. You're good.
Great. Nō reire, e mihi ana kia koutou, te komiti whakahaere, I runga I te hawatanga o tēnei kaupapa. Nō reire, e mihi ana kia koutou katoa. My name is Clark Pirika, and I speak today as chairperson of Te Pūmautanga o Te Arawa, representing 30,431 beneficiaries. Our organisation, a post-settlement governance entity for 11 iwi and hapu of Te Arawa, strongly opposes the principles of the Treaty of Waitangi Bill. We firmly believe this bill should never have seen the light of day. I appreciate the opportunity to present my oral submission to the Select Committee. While I will avoid repeating the kōrero already delivered, more eloquently around the technical components of the treaty and the principles bill by iwi and hapu leaders, politicians, both past and present, academics, rangatahi, and everyday New Zealanders who oppose this bill, I may reference their insights to reinforce key points. So, my kōrero will focus on two key issues, both of which reference a document written by Ministry of Justice officials as the advising agency to the Associate Minister of Justice, David Seymour. This document being the regulatory impact statement, providing certainty on the treaty principles, raises critical concerns. And I'm mindful of the submission from one of the speakers earlier on around the rigour, or perhaps the non-rigour, with regards to the process. So, point one, the impact on treaty settlements, both those already completed and those still in progress. And point two, the flawed process by which this bill was introduced to Parliament, affirming that it's a waste of time and resources. Point one. We're aware that the concept of treaty principles was first introduced by Parliament in the Treaty of Waitangi Act 75. While Parliament did not initially define these principles, it created a framework for the courts and the Waitangi Tribunal to do so. These principles have since served a critical purpose, and we believe they should continue to be articulated by the courts and the tribunal in accordance with existing legislation and practice. Currently, Te Tiriti principles appear in 40 pieces of legislation, ranging from simple acknowledgements to active implementation. Some of these are embedded in our own affiliate Te Arawa Iwi and Hapu Claims Settlement Act of 2008. This bill is not an isolated action. It is part of a broader policy agenda by the coalition government to weaken the constitutional status of Te Tiriti Waitangi. Other proposed changes, such as the Regulatory Standards Bill and the Resource Management Act rewrite, indicates a systematic effort to remove these references from significant legislation. Further, Principle 2 of this bill seeks to confine Māori rights and interests solely to treaty settlements, disregarding Article 2 of the Tiriti, which guarantees collective Māori rights. So if this bill is enacted, future treaty settlements would be assessed under the bill's redefined principles, likely resulting in outcomes that differ from past settlements. This is unjust. This is unacceptable. Moreover, the so-called 6-month select committee process presented as national conversation is deeply flawed. The treaty partner was not consulted. Any agreement between two parties should only be amended with mutual consent. Te Pūmautanga o Te Arawa affirms that Te Tiriti represents an agreement between two sovereign nations. The courts have already developed treaty principles in alignment with its articles, and this work should remain in their jurisdiction. This flawed process is being driven by a minor coalition party that received only 8.6% of the vote. It is inappropriate for them to claim the mandate to lead this conversation, especially after ensuring Māori were deliberately excluded from the outset. How dare the authors of this bill presume to know what is best for me and my people, and the hundreds of thousands who marched to the steps of Parliament only months ago, delivering a clear message to Te Tiriti. The 11 iwi and hapu that formed Te Pūmautanga o Te Arawa negotiated a settlement with the Crown based on trust and cooperation. That settlement was carried on the backs of our koroua, kuia, our uncles, our aunties, many of whom are no longer with us. And it's our duty to uphold their legacy. This bill undermines not only what our tūpuna fought for, but also the integrity of future settlements. My second point, the flawed process behind this bill. The introduction of this bill was procedurally unsound, and we call for its immediate dismissal. Sir Geoffrey Palmer, in his submission, stated that the process that led to this bill's introduction was fundamentally flawed, compared with the processes that are used for legislation customarily in your House. He further noted, orthodox policy processes for a bill like this would typically require in-depth analysis before decisions were made. Policy options would be assessed, interdepartmental consultation would take place, and crucially, Māori would be consulted. Instead, what we have seen is a bill that has clogged up the House with over 300,000 submissions, wasted an extraordinary amount of time and money, and damaged the collective fabric of our nation. This is what happens when proper legislative processes are ignored. A policy process does not begin with a bill, it ends with one. That is the fundamental flaw of this ill-considered legislation. And it was important for me to raise this again because those words of Sir Geoffrey Palmer resonated. And to our way of thinking, he was on the money. The contradictions here are striking. The government claims to prioritise fiscal responsibility, efficiency and resource management, yet the administration of this fraud process likely costs hundreds of thousands of dollars. I don't know. And this bill has consumed valuable time and energy that could have been better spent addressing genuine issues facing this country. So in closing, Prime Minister Luxon himself is on record stating, we don't agree with this bill. Treaty issues are complex and you don't negate with a stroke of a pen 184 years of debate and discussion with a bill that is very simplistic. Yes, we're supporting it to its first reading, but beyond that, we're not supporting it for those reasons. This fraud process rests squarely on the shoulders, my words, on the shoulders of Associate Minister David Seymour and Prime Minister Luxon, who allowed it to drag on as long as it has. So our call to action with regards to this, and I'm again going to refer to my submission here, we reaffirm our recommendations to the Justice Select Committee to withdraw the principles of the Treaty of Waitangi Bill immediately and urge the Prime Minister, you the Select Committee, urge the Prime Minister to honour his constitutional obligations above the coalition agreement. He must keep his word and ensure this bill does not proceed to a second reading or become law. Nō reira, e te komiti whakahaere, we implore you to do the right thing, withdraw this bill. E mihi ana kia koutou.
Naomi Clark, we've got a very short period of time. If anyone had a very brief question. No, look, can I just say really good submission, and thank you for your written submission as well. It's really appreciated and powerfully put as well. You can be proud.
Tēnā koutou.
Members, we've got a couple of minutes till our next submitter is due, 3 in fact, so, which is 12 o'clock. So I'm going to suspend for 3 minutes so people can just have a stretch.
Thank you, Mr. Chair.
Kia ora, members. I hope that was a useful break. Our next minute is Keith Rowe. We have Keith for 5 minutes. Right, Keith's coming online now. Just need video and audio and we'll get underway. You there, Keith? We need you to switch your audio at least on, preferably video as well. All right, we've clearly got some issues with Keith. Keith, if you can hear me, we need you to put your audio on so we can hear you. It may be that we need to go to our next submitter. We're having some challenges here. But if Keith can't manage that, we've got some technical difficulties. We'll go to Teo Agunlejika. Right, we've got Teo.
Yeah, me.
Got it, Teo. We can hear you. Can't. That looks good. And Teo, I think we have you for 5 minutes.
Yeah.
So I'll just hand over to you to speak to your submission on the Treaty of Waitangi Principles Bill. Kia ora.
Kia ora. Tēnā koutou katoa. Chairperson Honourable Dr. Duncan Webb, a member of the Justice Subcommittee. Thank you for the opportunity to make an oral submission in rejecting the Treaty Principle Bill. Recently, Tifatuora published a 2024 demographic report that described the geographic distribution and key demographic statistics of Aotearoa, Asian, and Middle Eastern, Latin American, and African in New Zealand. The report outlined the history of migration waves. First, the Chinese gold miners arrived in Aotearoa in 1865. From 1949, we start receiving refugees from various countries. And then from 1960s, we opened the visa for skilled workers from there, as well as international students. I highlighted this to emphasize that although the treaty was a partnership agreement between two sovereignties, however, precisely 25 years after the treaty was signed, other parties started to migrate to Aotearoa. But unfortunately, these other parties, for example, the Mila subgroup, who are the diverse ethnic communities, have felt that the conversation about honoring the treaty is one between Maori and Pakeha, in quote, the crown. More so, they aren't sure of their place in a treaty-based constitutional arrangement. And that is a thank you to the system and the media that made sure both migrants and former refugees settling in Aotearoa have limited or no engagement or the understanding of the conceptual of the treaty, New Zealand constitutional arrangement, and each person's right within that framework. The other point I will make in opposition to this bill is that facts matters to us as human beings, and that it is important that we ensure that in the debate that we are factual. The treaty principle bill and associated claims within it, and in its promotion of various websites are not accurate and present misinformation as truth. This sort of action causes tremendous harm to our society, especially around social cohesion and sense of belonging to ethnic migrants and refugees. And it also further harm the journey of belonging that new immigrants to New Zealand are undergoing. It is disappointing that people are leveraging the failure of the system to promote, engage, and educate the diverse ethnic community of Aotearoa about Maori and treaty, to disinform and continue to propagate negative narrative. As you are aware, it is disinformation that wins in any referendum. Contrary to people calling for referendum and from other jurisdictions, disinformation always wins. But education helps. And what furthermore, misleading content deliberately spread to deceive people and to secure economic and political gain, and which may cause public harm. And that's how I see this bill. At this junction, I would also like to stress that contrary to the narrative to divide us, Treaty of Waitangi isn't about ethnicity. It isn't about individual rights. It is a binding agreement between sovereignties, between the Crown and the Maori. Those are the two sovereignties. And I will refer you to paragraph 15 and 16 of my written submission for reflection. And if we really genuinely want to build consensus around treaty and our constitutional arrangement that will promote greater legitimacy and social cohesion, I think we should take these two paragraphs, which I'd call policy or legislative proposal.
Tayo, thank you.
Yeah.
We are at time, so we're going to have to cut you off there, but I think you've made your points really effectively. So thank you for that. And we do have your written submission as well.
Okay, thank you.
Thank you very much for your submission. Kia ora. Members, we're going to Keith Rowe, who we tried to get before, but we had some difficulties with. So we'll try to get Keith Rowe on. All right, so Keith is on the panel, and if we can get audio going.
Hello.
Kia ora, Keith.
You got me.
Yes, we've got you there. Look, we're under a wee bit of time pressure, but we've got you for 5 minutes. So I'm going to hand straight over to you to speak to your submission. Kia ora.
Thank you, Duncan. Well, greetings to you all, and thank you for the invitation to be with you today. I'm strongly opposed to the Treaty Principles Bill, and my written submission sets out the reasons, which I must say are similar to many others that you have heard and read. In this final day of oral submissions, I want rather to look ahead rather than back. I first of all want to encourage you as a committee, when you report back to Parliament, to express a very positive appreciation of the treaty and its vital role that it can and should play in the shaping of our nation. We're living in a world where we're facing enormous challenges, and the treaty is one of the ways into we will equip ourselves to face those challenges. So in this spirit, I want to make just 2 points. My first point is that in my judgment, the interpretation and the mana of the treaty is simply too important to be left to the political enthusiasms and ambitions of political parties, many of whose MPs simply lack sympathetic and informed understanding of our founding document. So my question today is, how can we protect our founding document and all it represents, the very soul of our nationhood? How can we stop it being simply reduced to a bargaining chip in the political game of coalition building? My suggestion is that representatives of Crown and iwi should be invited to explore how the treaty can be recognised as a living taonga, in a similar manner to the legal status accorded to the Whanganui River, Lake Waikato Moana and Taranaki Maunga, as a legal entity with personhood rights and with appointed guardians to protect its mana and to respect its living possibilities. Just as the guardians of a river, a lake or a mountain safeguard a geographical entity from being defaced, misused, exploited, or become the victim of political or economic vandalism, so the guardians of Tiritio Waitangi would care for Tiriti in a similar manner, challenging its misuse and reminding us all of its yet to be fulfilled possibilities. The courts and the tribunal have a continuing and vital role in rereading and interpreting the treaty in the light of today's questions. But in what I'm saying, I'm reaching toward a more symbolic, yet still decision-shaping way whereby the mana of the treaty is safeguarded. Note that a symbol is never merely a symbol. Symbols, whether they be flags, special places, or remembered events, remind us of who we are and who we might become. Certainly the treaty does that. What we mean by the mana of the treaty and the precise role of the guardians are matters of Crown and iwi working together to discuss and enact. Now, my second point is that we live in a time when locally and internationally, many are asking how Indigenous wisdom, with its strong environmental and community building concerns, can be brought into living and respectful conversation with Western ingenuity and preoccupation with monetary growth. It's becoming clearer by the day that a greed-based and environmentally damaging economic and social system inherited from the Western tradition primarily needs to embrace the best insights of Indigenous wisdom if we're to negotiate our way through the challenges of climate change, environmental degradation, the never decreasing gap between rich and poor, and add to that the perils and the promise of artificial intelligence.
Keith, I've just got to interrupt you and let you know you've got about 20 seconds left, so you need to conclude.
Well, I'm suggesting that we engage in a very serious and ongoing conversation between Indigenous and Western wisdom, between Kawanatanga and Rangatiratanga, and the history and the wisdom each represents. We should not underestimate the challenges that lie ahead of our grandchildren and their children. They will need all the wisdom, Indigenous and Western, that they can find if their generation is to contribute positively to human evolution. Western and Indigenous wisdom need each other if we're to make our way through the uncertainties of the future we face. I think that members of Parliament can and should lead the way in modelling what it means to draw on two traditions in decision making.
So we're going to go to our next submitter, Kakide Keith. That's very well put.
Thanks, Duncan. It's a privilege to be with you, and I wish you well in your deliberations.
Thank you very much. Members, our next submitter is the Tapuika Iwi Authority. I see we've got Helen online there. Kia ora, Helen. Good to see you. We've got you, I think, for 10 minutes to speak to your submission, which we have in front of us. And if we've got time, we may have questions as well. So over to you. Kia ora.
Tēnā koutou katoa, ngā mema o te harimata, kei te mihi kia koutou. First of all, Tapuika opposes the Treaty Principles Bill. Tapuika didn't sign Te Tiriti like our Te Arawa Whanaunga, so therefore we believe we didn't cede sovereignty. So I just want to tell you a bit about ourselves. So we're located in the Bay of Plenty. We are between Tauranga Moana and Te Arawa, and our tribal estate, or our takapu as we call it, taken 3 territorial authorities. They are the Western Bay of Plenty District Council, Tauranga City Council, and Rotorua Lakes Council. So our claim to fame would be that we are the kiwi fruit capital of the world for the moment. I haven't heard that that's changed as yet, but it could well do. In saying that, today, Tapuika settled in 2014. We are made up of about, on our register, we have almost 4,000. According to the stats, New Zealand 2023, we are 4,500 almost. So we have 4 marae and 5 hapu in our takapu, and almost half of us live in the Bay of Plenty region, so they're pretty in touch with our takapu. The median age of our people is 24 years old. So today we're bracing ourselves for an explosion of growth and development. So with the population pressures we're seeing in Tauranga, that has spilled out to the edges, and we're on the edges. So I liken where we're sitting at the moment to the precipice, and much like our tupuna did when settlers first arrived here. So we had Shane Jones, here's the Honourable Shane Jones here last week, almost 2 weeks ago now, for the opening of a bridge. He opened the bridge at the Rangiuri Business Park. That is the second biggest industrial park that's going up in our takapu. And so that was quite a bit of sweet experience. So a portion of our community celebrated that. It's good for the economy, it's good for the region. Our whānau actually mourned because that whenua was prime growing whenua of our tupuna. In fact, in the development of that park, they came across the evidence of our tupuna living on the land, and we know from our oral traditions and tātou kōrero that our tupuna lived on that land, how they lived on that land, who lived on that land. So to find that evidence was pretty amazing, but at the same time, you have an archaeological authority that can actually sweep the whenua clean of our identity. So it was a bittersweet, and we're still coming to terms with that. So we have legacy issues that we're dealing with. We have a fairly young demographic, but the legacy issues that we live with today is that beside one marae in the paddock down the hill, we have a quarry. We have another marae that is built by a stream where back in the 80s Western Bay put the wastewater treatment plant. Just in recent years, I think it was 2010, we went to the Environmental Court. As a result of that, Tauranga City Council and Western Bay were able to obtain a water take from a pristine water source. So in the minds of our people, our councils conspired with each other to take our water. And incidentally, I found a document about 2 weeks ago that actually said that back in 1999, Tauranga City Council identified the Waiere as a water source. In 1999, they commissioned a report. They needed Bay of Plenty Regional Council's help to do that report, and Western Bay of Plenty District Council were in the mix as well. And so by 2002, when they came out to meet with our tupuna to ask if we agreed to the water take, they said no. But when I think back now, at the time and all the huis that they had at our marae, our people categorically said no. Yes, I understand now that looking back, they had already scoped it out. They had commissioned a report, and we knew nothing about that. And that actually speaks to the relationship that we've had with local councils. We've made a concerted effort to actually sit down with them, because now, as I said, we're looking at development running a full ball over our takapu. The thing is, for us and for our mokopuna, where is their place? Already there's been talk of a 45,000 city going up in our takapu. And so that's due to the pressures of population growth along the coast in the Bay of Plenty. So we're actually going to be hammered. But the thing is, where is our place and our future on our takapu? So when I come back to the bill and the coalition government, at their first 100 days of being in government, we knew straight away that we were going to be in trouble. Our story is nothing new. It's quite common across all Māori. But the amount of change and new legislation that we had to respond to without resources, I might add, there was absolutely no resources. And in saying that, the funding that we got to employ myself at the iwi authority was through Jobs and Nature, and that coalition government cut that as well. That was really exciting. It was the first time that our people were able to get out and be kaitiaki across our whenua. And so the funding that is cut like that, it means so much to us. It's been really disappointing, worse than disappointing actually. So when I look at the future in our takapu, I think about our waterways. When we settled in 2014, the issue of water ownership, or rangatiratanga of water as we like to call it, was parked. And so in that time, other people are able to come along and manage that water and take that water, and we had no say. And it astounds me that we are now in 2025 and we're still sidelined from having a real say in what happens in the development of our tribal estate. I'm excited and I'm sad for the future when I think about this bill. I just want to add the words, and you've probably heard them all before. This bill, the process was flawed, it's divisive. It's allowed across social media, it's allowed the closet racists to come out and be very overt. and it's given them a licence to Māori bash, which is what we experience. Now, I have a mokopuna who is 11 years old. When she was 6 years old, she told me, because she's quite dark, she told me she wanted to be white, she wanted to be fair. Because society teaches us, then teaches our mokopuna that they are not valued. And we see this all the time. And so, for my mokopuna and their future, I think about their place in our takapu and their place in shaping the future for our people. And so, when you have a bill like this, I would recommend to the committee that you throw the damn thing in the rubbish bin where it belongs. Because that's honestly where it belongs. It has caused...
Helen, just letting you know, you've got about 30 seconds to just wind up at this point. So.
Okay. So really, I think about our mokopuna in the future. I want a bright future. The work of Moana Jackson, constitutional transformation, that's exciting stuff, and we should go there. And I'll end it there. Kia ora tātou katoa.
Kia ora, Helen. Thank you for that. We don't have any time for questions, but thanks for coming online to make your submission. Members, our next submitter is Rangatohu Nathan for 5 minutes. Just wait for the audio and video to come on. We've got audio. Kia ora, good to see you there. Thanks for coming online, and we have your submission in front of us. So we've set aside 5 minutes to hear from you, so I'll hand straight over to you. Kia ora.
Kia ora tātou. I've just listened to the kōrero from my whanaunga, and so I'm going to quote how I'm connected to her. Ko rangi uru te maunga, ko kaituna te awa, ko tapuika te iwi, ko Ngāti Tuheke te hapu, ko makahai te marae, he uria hau o tapuika tū tonu. I listened with interest to her kōrero because it impacts directly on, I guess, some of the kōrero that I wanted to have today in support of my submission. I guess those of you that have read my submission will see that I'm a little bit idealistic when I make the comments that I do. I refer to our tūpuna who back in 1840 considered carefully how they would respond to the Crown at that time, asking them to sign a treaty that they had no input into, and that very little consultation and opportunities to challenge what was in Te Titi. They were given very little opportunity to do that at the time. And I'd like to comment here that this is something that continues. It's continued in our history as we have been colonised, as various breaches have been made to that agreement, because many of our tūpuna signed Te Titi o Waitangi, and they did so knowing that they were making an agreement, and hopefully making that agreement with someone as honourable as them. The fact that perhaps that was a bit misplaced for them to believe that, because following the signing of the Treaty of Waitangi, the breaches began. They began within the year that that treaty was signed. And so in the last 185 years since the signing, we have seen a succession of breaches to what was agreed to, and these breaches were and continue to be made through legislation by the Crown. I see this bill as yet another breach, and probably one of the most dangerous to date. Greed and arrogance were driving forces behind many of the historical breaches. Ignorance and fear drive this one. During the hikoi, gathering of hikoi, I and some of my whānau decided we would join the hikoi in Rotorua. And as I did that, I felt the wairua of my tipuna. I felt them saying, haere tonu rangi tuahu. And so I did. And for my troubles, I have 2 black big toes from the shoes that I was wearing. But anyway, it is that plus the fact that during the time that Helen spoke of some mahi that we did as an iwi, and it was during that time that I became aware that there is an important place for Te Titi o Waitangi that was signed back in 1840 for us now. The bill would suggest...
I want to let you know you've got about a minute left, and Huhana Linden would like to ask you a question. Would you like to answer that question?
Okay, pātai mai.
Tēnā koe te hea mana o tira, tēnā koe whairangi tuohu. I just want to mihi to you as an elder, coming before the select committee and sharing your wisdom with us. And I wanted to know from your perspective, give us some straight advice as to what you think we should do with this bill.
Okay, I think we should set it aside. I think it has no benefits for Māori and perhaps for our iwi katoa on this whenua. I think that it should be set aside. I think that if anything were to be done, and I don't think anything does need to be done, if you've read my submission, you'll see that I suggest that it should be left as is, and there was nothing wrong with what our tupunas did when they signed Te Titi o Waitangi. They knew what they were doing. They knew that they were trying to find the safest way for the future of their iwi. And we are that future. And so I think it should be set aside. But I just want to make, and probably this is going to be in my closing remarks, I just want to make these last comments, if that's okay. We perilously cling to the whakaaro that honour our tipuna. Those rangatira who were asked to sign a treaty that they had no input into and were given little opportunity to challenge. And this is not a new strategy. But however, they went ahead and signed. And I'm grateful to them for doing that. I mihi to them. I hope that I honour them with my kōrero today. As I considered whether I would present orally my submission, I wondered if even speaking out would make any difference to how our current coalition government would deal with this take. So I say, a te whakarongo e te karauna, tēnei paremate, tēnei komiti hoki. A te whakarongo ki te tangi o ngā iwi o tēnei whenua. The mamai that has clouded our history and continues to obscure the future of our tamariki mokopuna should be your main concern, and not a bill that has the arrogance to suggest the whakaaro and consideration of our ancestors needs further clarification or even nullify.
Kia ora, rangatahi.
Kia ora tātou.
Thank you for your submission, very well put. And as Huhana said, thank you for your wisdom. Harera. Members, our next submitter is Douglas Higgins, who we also have for 5 minutes. Kia ora, Douglas. We've got you here. Haven't got you on video yet, but that's okay. We've got you here for 5 minutes to speak to your submission. If we get a chance, there may be questions. I'll hand straight over to you. Kia ora.
Okay, sorry that I can't get the video to come on. That's just not working. Okay, thank you, Mr. Chair. At the outset, I wish to commend the Select Committee for ensuring due process of consultation and ensuring that the unprecedented number of written and oral submissions are considered. No one can claim that the voices of the people have been thus far suppressed. The descendants of those who signed the treaty those who didn't, and those who were not given opportunity. All have been given an equal opportunity to make their views known on this bill, which is of fundamental importance to every New Zealander. While this process reflects good governance in the 21st century, it is a far cry from the lack of due diligence that was the norm in the early 1800s. Months after the signing in Waitangi, the treaty was taken around the country and even eventually to the South Island, by which time it was largely a rubber stamping exercise. However, the itinerary didn't include Nelson and Tasman, from where I hail. So this current process being managed by the Select Committee is unquestionably commendable, and I thank you. Due to the limited time, I'll cut straight to aspects of the draft bill that may require amendment. Firstly, in Principle 3, Paragraph 2b, the use of the phrase fundamental human rights. While New Zealand accepted the Universal Declaration of Human Rights and became party to the 2 international human rights treaties, we have been slow to integrate human rights into legislation. This begs the question of the intended scope of fundamental human rights in this draft bill. New Zealand has signed and ratified the Convention on the Rights of the Child, wherein there are several references to a child's right to cultural identity and values. Article 30 reads, in those states in which ethnic, religious, or linguistic minorities or persons of indigenous origin exist, a child belonging to such a minority or who is indigenous shall not be denied the right, in community with other members of his or her group, to enjoy his or her own culture, etc., etc. This is a fundamental human right which New Zealand is obliged to uphold under international law. So back to Principle 3 in our draft bill, the intended equality of everyone will be conditioned by the application of human rights. If Principle 3.2b was amended to read, the equal enjoyment of the same human rights that are incorporated into New Zealand law through statute, common law, and international human rights instruments, then the vague reference to fundamental human rights would be sharpened. Maori and non-Maori alike would be better protected, and many of the objections submitted to the Select Committee would be addressed. At the height of British colonial policy making in the early 1800s, the concepts of human rights, equality, and much less equity didn't exist as we know them today. The treaty is therefore silent on these critical matters. While the treaty will always be of preeminent historical significance to our nation, to regard it with the emotional notions of being sacred into perpetuity, or of its beautiful simplicity, or, as an erstwhile second-hand Prime Minister claimed, of its being profound. These notions are unhelpful for unshackling us all from colonial trauma and for moving forward as a nation. While the bill introduces the necessary lens of equality, there is no reference to acknowledging the need for equity. Both terms, equality and equity, aim for fairness, but in its narrow sense, equality assumes everyone is on the same footing, more or less. Equity recognizes that people, individually or social groups, are not on the same footing and require different types and levels of support to achieve fair outcomes.
Douglas, I'm just going to let you know you've got about 30 seconds to wind it up.
Okay, in our country, the ethnic disparities and outcomes of, amongst others, health, learning, and conflict with the law are such that it is entirely inappropriate to gloss over the distinction between equality and equity. The draft bill needs to be sharpened in this regard. In closing, I support this bill, the due processes of consultation and amendment, and eventually the proposed referendum. Eventually, while remaining respectful, we will be free of British colonial policy practices as embedded in the Treaty of Waitangi, and given the opportunity, this bill could contribute to that. Thank you.
Thank you, Douglas. We don't have any time for questions. We're a wee bit over, but thanks for your submission. Haere. Members, we have Kahui Legal as our next submitter, and I see we've got Lionel Tapihuria online. Kia ora, Lionel, good to see you. Thanks for coming online to submit and speak to your written submission. And I see we've got Abby as well. We've got you for 10 minutes. So in the interest of time, I'll hand straight over to you. We may have questions at the end. Kia ora.
Tēnā koe te haimana o te rā, tēnā koutou I ngā mema o te komiti. He uri au no Ngāti Ruanui, ngā Rauhine-rangi, ngā Rauru Kītahi, ko Lanao Tawhihuria tōku ingoa, ko te tumu whakahaere o kāhui legal au. Kei konei māua ko Abby Hauraki, tōku hoa mahi o kāhui legal, tēnā tātou katoa. Thank you for the opportunity for me and my colleague Abby Hauraki to present today. I will hand over to Abby once I make a few introductory comments. We are presenting today on behalf of Kāhui Legal. We wish to make it clear that our firm opposes this bill and we recommend the immediate withdrawal of this bill. Kāhui Legal is a law firm that was established in 2003 by Mātānuku Mahuika and Jamie Ferguson, both whom have appeared before this committee. We could talk more about the many illustrious alumni, leaders across the legal profession, business leaders and leaders across Te Ao Māori. But for today, and more importantly, we want to acknowledge the clients we have acted for, including whānau, hapu, marae, iwi, Māori individuals and organisations. These clients have come to us seeking new and innovative solutions to address a wide range of inequalities and inequities they have faced and continue to face on a day-to-day basis within a system that has stolen their lands, had suppressed their tohunga, had forbidden their language, had taken their children, incarcerates them at an alarming rate, stripped away their takutai Moana rights, reinstated those rights, and is in the midst of wrestling them down again, a system that has basically failed Māori at every opportunity. It has been our privilege to be involved in many cases seeking recognition of Te Tiriti o Waitangi, tikanga and Te Ao Māori frameworks across the legal system and within every fabric of our society today. Given the atrocious conditions and circumstances that Māori faced leading up to the cases we were involved with, it is important to recognise the outcomes that were sought were often hard fought for, required significant sacrifice, demonstrated our clients' commitment, hope and love for a better Aotearoa, but most importantly, demonstrated a commitment to honouring the rights and promises acknowledged and recognised within Te Tiriti o Waitangi. Despite our country's turbulent history and despite the challenges that still exist within our legal system, we think it is important to highlight that there have been some examples where we, Kāhui Legal, have worked alongside Māori and the Crown in a positive way to advance the aspirations of Māori, despite the fractured Crown-Māori relationship. We were able to work together and still deliver positive outcomes, including economic, social, environmental, political, and cultural outcomes. We see this today as I present to you from outside the crowds at Te Matatini, within the Rohe o Taranaki, where the status of Te Kāhui Maunga as a tupuna in its own right has been recognised, where the name Parihaka is protected and entrenched in legislation. We're on my way home, on my way here yesterday, we drove through the Rohe o ngā iwi o Wanganui, where Te Awa Tupua also has personhood. These types of outcomes have been effective for rebuilding Māori Crown relationships and to help address the atrocities of the past. This could only be done because Te Tiriti o Waitangi exists. The proposed Treaty Principles Bill is an attack not only on Te Tiriti o Waitangi, it is a direct affront to the many clients we have worked with for over 20 years, clients who have sought those outcomes that benefit Aotearoa as a whole, despite the challenges they faced. The public funds that have been wasted on this process could be better invested in measures that will enable Māori, Māori frameworks and the Māori economy. For example, every day we see our clients impacted by the under-resourcing of the Māori Land Court, which then impacts on their ability to use and develop their whenua for the benefit of their whānau, including delivering key infrastructure such as papakainga housing and green energy developments. While the Crown may wish to take us back to the pre-1975 position, it is too late. We witness daily organisations who are already working with Māori in partnership to give effect to Te Tiriti o Waitangi. Those businesses, large and small, recognising the importance of tangata whenua relationships to their social licence. The Crown can try to tinker with things, but ultimately businesses respond to the needs and wants of their consumers, and consumers are expecting more from the businesses they purchase from today. This Crown will need to keep up. Another group the Crown will need to keep up with is the next generation of Māori leaders, and at this point I would like to hand over to an example of one of those future leaders, my colleague and teina, Abby Hauraki.
E te komiti, anei te uri o Ngāti Kaharau o te whānau tūwhaka iriora e mihi atu nei tēnā koutou. Ko Abby Hauraki tōku ingoa he kaiwawa matua ahau ki Kāhui Legal. Our name, Kāhui Legal, was gifted to us by the late Api Mahuika, a great rangatira o Ngāti Porou and the father of one of our founding partners, Mātānuku Mahuika. Our name stands for the gathering and bringing together of all kinds of peoples. In our line of work that includes our clients, the iwi, hapu, whānau, individuals and many Māori entities we represent, our lawyers and the Crown. Kāhui represents a flock of birds flying together or a constellation or cluster of stars. Our name binds us together in our endeavours, it protects us in our mahi, and it gives us strength. This bill is the antithesis of what our name represents. Rather than bringing people together, it has and continues to sow division. I too have just returned home to Pōneke from Ngā Motu, where Lanau currently is and where Te Matatini is taking place. By the end of this process, you at the committee will have heard over 80 hours worth of submission, and yet some of the best oral submissions are currently being presented on the stage at Te Matatini beneath Koro Taranaki. Performers and composers who are direct descendants of the rangatira who signed Te Tiriti o Waitangi have taken the mamai and the division that this bill has caused and turned it into art, because that is what we as Māori do. Our haka, our motiatea, and our waiata are records of history. They mark battles, natural disasters, great love stories, and even greater heartbreaks. And currently, those kapa are weaving this bill and its author into the fabric of our oral history so that we may never forget that 185 years after the signing of Te Tiriti, and after more than 4 decades of incremental progress to restoring a Crown Māori relationship marked by broken promises, the Crown by this bill would yet again take an axe to Te Tiriti o Waitangi. E ki, nā wai he katahi katino he ke atu. Māori now make up 20% of the population and we are growing. We can expect more Māori leaders across Aotearoa in all areas and the future looks bright. We are seeing this in the legal sphere. At Kāhui Legal, our next generation of lawyers include graduates from Te Kohanga Reo and Te Kura Kaupapa Māori. They are skilled in both Te Reo Māori and English, the New Zealand legal system and tikanga Māori. They are our future law firm partners, King's Counsel and judges, and they will be experts in both legal systems. Our time and resources would be better spent investing in the next generation of thinkers and encouraging frameworks that enable those leaders to flourish and take our society forward as a whole. Instead, it is wasted debating this bill, a bill that is inherently cynical, flawed, and factually wrong. That is a tragedy for a number of reasons, but especially because Te Tiriti is essentially a hopeful document. The Waitangi Tribunal captured this position in its all-embracing Ko Aotearoa TNA report. It said, "It is in the fact that the agreement at Waitangi took the form of the treaty that we see mutual respect for each other's mana. And it is in the treaty's words that we will find the promise that this respect will last forever." Nā reira, reflecting on those words, I turn finally to the leaders of tomorrow. Kei te reanga whakaheke, koutou e takahi ana I tēnei ara, hei ngā tau e heke mai nei. It is very clear, mokopuna mā, that there is much more work for us to do. As Te Rangiura o Wairarapa so eloquently expressed on the Te Matatini stage this week, e hikoi tonu ana tātou, mo te tiriti, mo te whenua, mo ngā mokopuna. Ka ora tonu tātou ake, ko te tino rangatiratanga nōku, nōhou, he hikoi te haere. E ngā mokopuna, just remember, you never walk alone. Nō reira, e te komiti, tātou e hui mai nei, tēnā koutou.
Tēnā kouara, thank you for that. Look, we're pretty much out of time. We don't have time for questions, but can I thank you for coming on and speaking to your submission, and thank you for your written submission, which we have in front of us as well. So, kia ora koutou.
Ngami.
Ngami.
Members, our next submitter is Network Waitangi Otutahi, and we have them for 5 minutes.
Yep, are we on? Yeah. Yep. Ngā mihi nui kia koutou. My name's Catherine Peat and this is Archie Hunter. We're from Network Waitangi and it feels really good to be following the previous speaker.
Today, we want to bring your attention first to the preamble of Te Tiriti and the need to consider this living document as a whole. It is essentially a treaty of peace and friendship between Māori and the Crown. We need the friendship and peace envisioned in Te Tiriti more than ever at this time. It is a framework for the future. The approach of this bill ignores the context in which Te Tiriti was signed, including He Whakaputanga, the Declaration of Independence, recognised internationally 5 years earlier in 1835. Te Tiriti acknowledges the authority of Māori, rangatiratanga, and establishes a new form of delegated authority, kāwanatanga. The preamble states that this was to address the lawless state of Pākehā settlers in this country at the time, and for those who will come later. With this purpose for the treaty in mind, and noting that there was only 2,000 Pākehā in Aotearoa me te Waipunamu in 1840, compared with over 80,000 Māori, it is nonsensical to suggest that Māori ceded sovereignty over their own affairs to the British Crown. In 2014, the Waitangi Tribunal, with extensive historical evidence and support, agreed that this was the case in their report on the Ngāpuhi claim, Y1040.
In Network Waitangi, we have a particular educational focus in 2025 on the responsibility of tangata tiriti to build honourable kāwanatanga in support of the restoration of tino rangatiratanga by tangata whenua. In our educational work over 40 years, we've always asked our participants the question, what really matters? Responses include family and friends, being just, love, safety, connections to place, being in nature, respect, kindness, and having purpose, and many others. These values complement those identified in the Matiki Mai report, which held over 250 hui across the country and discussed what values tangata whenua would like to see underpin our constitutional arrangements. This bill ignores the context needed to enact these shared values that really matter. Reference to the maintenance of a free and democratic society is limited in this bill to the maintenance of equal property rights. It redefines and individualises the collective dimension of equity and distorts its full meaning as shown in this cartoon. The focus on individual rights would undermine many of the values that we embrace as a country. As Ngāi Tahu Kaiwhakahaere, Justin Tipper, recently submitted, this bill is destroying the fabric of this nation.
The obligations of the New Zealand government under Te Tiriti o Waitangi exist independently of the treaty principles, and this bill gives no indication of how the government intends to meet those obligations without principles that reflect the agreement made in 1840. Despite the unjust and ahistoric approach of the current government, exemplified by this bill, we remain hopeful as reasonable and decent people in this country are devising new ways of working and learning how to build respect for and understanding of tino rangatiratanga and the delegated authority of kāwanatanga.
In conclusion, this bill would create the most comprehensive breach of te tiriti in modern times. As a treaty of peace and friendship, where tangata whenua authority has upheld its side of the arrangement, it's time for kāwanatanga to act honourably. We recommend the bill be withdrawn at the earliest opportunity and thus end this attempt to redefine the principles which completely undermine this government's responsibilities to honour te tiriti as a whole, including the preamble.
Kia ora, Kathleen.
Will be appreciated.
Look, we've got less than a minute left, but if Huhana can ask a quick question, we may have time. We won't have time for you, Takata. Sorry.
Tēnā koutou, Network Waitangi, and thank you very much as colleagues and allies for Te Iwi Māori standing strong for Te Tiriti and acknowledging He Whakaputanga. I wanted to ask around the education element of what you bring into community And do you think it's time that networks such as yourselves and Te Tākura educators, the many people who are doing awesome work in this area, need to be resourced more to go into community and be able to support greater understanding around these foundational documents for a better Aotearoa Te Waipōna moving forward into the future?
Yes, of course, and it needs to have a framework to feedback, because it needs the overall policy commitment to actually make this happen, or it just will go on squidging.
Thanks, Kathleen. As you can probably hear, we're out of time. Thank you for your submission. Really useful. Thank you for your work. Ka kite. Members, our next submitter is Epilepsy Waikato Charitable Trust, and we have them for 10 minutes. I see we've got Stephen online there. Once we get some audio and video, we'll get underway. Kia ora, Stephen, and I see you've got a colleague with you. We've got your submission.
Yes, this is Esther.
Yes, we can hear you. Yep, we're all good. We've got you for 10 minutes. In the interest of time, I'm just going to hand straight to you. Kia ora.
Tēnā koutou katoa. First of all, thank you for the opportunity to follow up on our written submission. Esther and I represent the Waikato Epilepsy Waikato Charitable Trust, and our guiding principle is he arahanga whakamua. And today we're here to lead the way by opposing the principles of the Treaty of Waitangi Bill, particularly its third so-called right to equality principle, which we believe contradicts Article 3 of the treaty. It was quite good following the previous speaker's cartoon, because equality before the law sounds fair, but this bill ignores the deep inequities Māori face in health, including epilepsy. Now, you probably know epilepsy is a serious brain disorder that affects people of all ages and backgrounds. It affects around 1 in 100 people in New Zealand, or around 50,000 New Zealanders. Now, 10,000 of whom will identify as Māori. But Māori experience worse health outcomes across nearly all measures, and in epilepsy specifically, Māori face systemic barriers that non-Māori do not, and we'd like to talk to those for a minute. So we're drawing heavily today on research by Dr. Nairi Keenan, who shows that tamariki Māori are more likely to be sent home from the ED, even though they present in similar proportions to their peers. They have longer median wait times to see medical specialists when referred to outpatient services. They're less likely to get an MRI scan when needed, and when they do, they find themselves waiting a median of 12 weeks longer. And they're less likely to see a pediatric neurologist, and you guessed it, they wait longer. So let's be clear here, Māori kids with epilepsy don't get the same care as Pākehā kids, even when you account for socioeconomic status and rural location. But inequities remain.
So this bill claims to promote equality before the law, but equal treatment does not lead to equal outcomes. Picture this: 2 kids, same hospital, same condition, one's Māori, one's Pākehā. Under this so-called equal system, both have the same legal right to care, but in reality, the Māori child is more likely to wait longer, receive less care, and face worse health outcomes. That is not equality, that's systemic inequity disguised as fairness. The same rules for everyone don't fix systemic disadvantages. In my work with Māori clients, I see this firsthand. They're more likely to need advocacy, whether with medical professionals, social services, ministries, or housing providers. The impacts of epilepsy ripple through their lives. And for those in rural areas, access to services is even harder. Te Tiriti isn't about a shallow one-size-fits-all approach. It's about real partnership, participation, and protection. The Crown has an obligation to address inequities, not ignore them. The failures of the health system show why special measures are necessary. By stripping recognition of the true treaty principles, this bill weakens the Crown's duty to ensure Māori well-being. Partnership, participation, and protection look like the by Māori, for Māori approach. It means ensuring Māori can access services that meet their needs. In my role, I work alongside several Māori health organisations, including Te Koho Health, Te Toi Ora Ki Whangaroa, National Hauora Coalition, Ra'awa Kamatua Charitable Trust, among others, to offer clients choice.
So we believe that this bill doesn't create fairness. It removes targeted action that Māori desperately need. And ironically, it's exactly the kind of targeted action that the government has signed up to and agreed to when it signed the World Health Organization's intersectoral global action plan on epilepsy and other neurological disorders. If the government truly cares about justice, it can't ignore these disparities. It has to act. So we believe that true equality means acknowledging the reality of inequity and taking steps to fix it. We urge this committee to reject this bill and instead uphold the real purpose of Te Tiriti, which is to ensure that Māori thrive as equal partners in Aotearoa. So on behalf of Esther and myself, we'd like to thank you again for the opportunity to be able to present today. And if you have any questions for us, we'll do our best to answer them.
Yeah, Ngā mihi, thank you for that. Members, we do have some time for questions if anyone has some. Look, no, it appears not, but thank you for your submission. And can I say thank you for your written submission, and I see the references there as well. So thank you for that, and thank you for coming online to speak to it. So
no problem. I really would suggest, looking at Nairi Keenan's research on epilepsy between Māori and non-Māori in New Zealand, it is
very telling.
Yeah. Yeah.
All right.
Thank you again.
Okay.
Thank you.
Look, Huhana, if we could have a quick question.
I just wanted to ask if the details of that research can be circulated to the clerk, and then we can receive it as a part of our paperwork. That would be great.
Yeah.
Yeah.
Okay.
Unfortunately, her thesis is still embargoed, but there are abstracts of her presentations that are available and can be.
Okay. Well, if you could email the details of that to the Select Committee clerk, then they can provide it to us. Thank you for that.
Thank you.
Members, our next submitter is Kindergartens Aotearoa. We have them for 10 minutes, and I see we've got Tara Solomon all ready to go. So Tara, thanks for coming online. Good to see you. We've got your written submission. We've got you for 10 minutes, and so I'll hand straight over to you.
Kia ora, tēnā koutou katoa. Ko Tara Solomon tōku ingoa. I'm the CE of Kaishaki Kindergartens, and I'm part of Kindergartens Aotearoa, which is a collective of 6 regional kindergarten associations around the country that operate more than 260 of New Zealand kindergartens, catering for more than 12,000 children each day. As an organisation dedicated to the education and care of babies and young children and their families and the well-being of whānau and communities, we oppose the bill because it threatens to erase Te Tiriti's guarantee of tino rangatiratera and remove a key legal framework that has supported informed pro-equity social policies, including included in education for decades. This is because the bill seeks to remove the requirement for education leaders to be giving effect to Te Tiriti of Waitangi. This would redefine those rights as they appear in numerous acts of Parliament, including but not limited to the Education and Training Act 2020. Early childhood education lays the foundation for lifelong learning, and research, both local and international, consistently shows that recognizing a child's language, culture, and identity is essential for their educational success. Studies also indicate that children who feel secure, confident, and see themselves as learners are more likely to make a smooth transition to school. In particular, valuing and honouring Te Tiriti o Waitangi plays a crucial role in nurturing this confidence and a sense of identity, both for all children and for Māori children in particular. This bill has the potential to undermine Māori educational success, which directly contradicts the goals of government, indeed objectives of all governments. When Māori thrive, we all thrive. The importance of this issue is even more significant from both an economic and ethical standpoint, especially when considering the increasing number of Māori tamariki in education and the projected growth of this group in the coming century. Since 1989, when centres were required to have a charter which included clauses relating to the treaty, early childhood services have been on a trajectory to recognise and honour Te Tiriti. This has been accompanied by greater knowledge of Te Reo Māori and Tikanga Māori, greater awareness about Te Tiriti from staff and families, and greater commitment to reflecting Māori values, language and culture. This bill seeks to negate and reverse these years of progress. Furthermore, national early childhood curriculum, Te Whāraki, is a bicultural one, developed with and supported by the sector since 1996, now 29 years. On page 3 of our curriculum, the implications of treaty for early childhood education are clearly spelt out. These are all well understood and respected by kaiako staff and whānau within our sector and our services, to everyone's benefit. This bill has the intention of undermining respect, support and goodwill in relation to the treaty, thereby jeopardising the delivery of our curriculum, which is revered around the world. The bill threatens the foundations of our education system and equity in Aotearoa, New Zealand in multiple direct and indirect ways. This will have a negative impact not only on our tamariki Māori, but on all tamariki from all cultures who live in Aotearoa, New Zealand. To this end, we urge the Select Committee to recommend that the bill not proceed, that they encourage meaningful engagement with Māori. Any discussion regarding the interpretation or application of Te Tiriti must be led by and in partnership with Māori, and will reaffirm Te Tiriti of Waitangi as our founding document of Aotearoa. Happy to answer any questions.
Thank you for that, Tara. I see Huhana has a question.
Kia ora, e mihi atu ana ki a koe, Tara. Thank you for coming in on behalf of the Kindergarten Association and recognising the work of early childhood and implementing Te Whāraki over the last 29 years. Are you able to share with us the journey of kindergarten and the way that you have implemented Te Whāraki and that bicultural lens, Te Tiriti o Waitangi, within the front line with our babies and whānau of kindi?
Yeah, it has become part of an everyday thing that we do. It's a living thing to embed it in the partnerships and what we recognise in kindergartens as we've embedded Te Tiriti and those principles of partnership and protection for Māori is that the benefits have rippled out to the families and to the communities of all of New Zealanders and all of the families that come from immigrants that come to join us. There's so much research has gone in and shown that that sense of belonging that people feel from understanding their culture and knowing who they are and that identity sets them up for a lifetime of success. And I think this is what is important, is that we at the moment, it's not something that we need to allow people to choose to do. This needs to be something that is embedded in everything that we do. And so to take it away from that nature, to say that it may be something that you can choose to do, it takes it away from the essential naturedness of Te Tiriti of Waitangi, and that actually it is our founding document for us all to be here to and we see how the mana of our tamariki, of our mokopuna, and how that it inspires them and grows them, and how they're teaching, they become the kaiako of their whānau, of their families. And so it's really integral to everything that we do, including also our kaiako, our practices, and what we've learned and grown. So in kindergartens, it's the ripple effect, I think, that it has that becomes so important, because it's not just what's happening in the centres, but what's happening in the wider community as well, and the impact it's having.
Kia ora, Tara. Thank you for your submission. Thank you for your written submission, but really well expressed. So kia ora and haere. Thank you.
Thank you.
Members, our next submitter is the Gisborne District Council. Who we have for up to 10 minutes. Kia ora, Nadine. Thanks for coming online, and thank you for your written submission as well, which we have in front of us. We've got you here for up to 10 minutes, including any questions that we may have. So I'll hand straight over to you. Kia ora.
Hi, thank you. Kia ora tātou. And firstly, an apology from Mayor Stoltz, who is unwell today. I'm the Chief Executive, Nadine Thatcher-Swan, from Gisborne District Council, and I'm here on her behalf to present her speech, or our speech, in opposition to the Treaty Principles Bill. And thank you to the committee for giving us this time to present our oral submission. You have our submission. I won't repeat it, but I do want to highlight a few points. At the high level, the bill has significant implications for local government and our partnerships with Māori and the well-being of our communities. It's also a complete distraction from the critical work we are doing, including RM reform and ensuring our water services are delivered well. Gisborne District Council's position is clear. This bill must not proceed. Te Tiriti o Waitangi is a foundation of Aotearoa and our commitment, our promise, and our future. The Crown has an obligation to honour its principles and uphold its partnership with Māori. This bill is not just words on a page, it's a breach of trust and a complete step backwards. Every day, our council experiences the strength of Māori leadership, the depth of tikanga, and the resilience of our community. We stand shoulder to shoulder alongside our tiriti partners, and we will continue to do so. The bill threatens to undo the partnerships that we have taken decades to build and weakens Māori participation and governance. Local government has worked in good faith to honour the principles of Te Tiriti, not as a symbolic exercise, but as a guide to inclusive decision-making. Our council, like many others, has implemented co-governance arrangements to ensure sustainable and fair decision-making, and this bill jeopardises that progress. It also creates uncertainty around treaty settlements. While it upholds them in principle, it changes the legal foundation of these agreements, making it harder for councils to honour their obligations to iwi, as many of us rely on treaty settlements to guide co-governance arrangements, land management and partnership agreements. So introducing the treaty principles that differ from those past settlements will create legal inconsistencies, as many have shared before. Second, the bill restricts our ability to negotiate future settlements by stating that any distinct Māori rights can only come from historical treaty claims, which ignores the fact that treaty relationships evolve and that new grievances may arise that need for fair resolution. And local governments work closely with iwi on this, and land use and economic development and environmental management, and these partnerships are crucial for our prosperity. In short, this bill risks undoing decades of progress. It creates legal uncertainty for councils. It weakens co-governance relationships. And we urge the committee to consider the practical consequences of this bill and ensure that local governments can continue to work constructively with iwi for all the good of all New Zealanders. In Te Tairawhiti, where 56% of our population is Māori, Te Tiriti is not just history, it is a living framework that reflects who we are. Any attempt to redefine its principles without tangata whenua involvement undermines its foundation. And like many submitters, we are deeply concerned by the lack of genuine consultation with Māori on this bill. Te Tiriti establishes partnership, yet the process has disregarded that fundamental obligation. Māori must have a voice in decisions that impact on them. Local government is about working alongside communities, not making decisions in isolation. And if we fail to engage Māori properly, we risk repeating the mistakes of the past, damaging trust and deepening inequities. Mayor Stoltz would have been here today, not just as mayor, but as someone whose life has been shaped by systematic injustice. Born and raised in South Africa under apartheid, she experienced firsthand a system designed to strip away dignity, erase identity, and deny self-determination. When she came to Aotearoa, she saw a country with its own history of injustice, but also something unique, Te Tiriti o Waitangi. Unlike apartheid, which excluded and oppressed, Te Tiriti represents a commitment to inclusion, equity, and partnership, a commitment that Aotearoa should be proud of. As mayor, she's had the privilege of working alongside our iwi, hapu, and whānau in Te Tairawhiti. She has seen firsthand the strength of Māori leadership and the power of true partnership. That is why this bill is so concerning. It threatens to undo Aotearoa unique. It dismantles progress and takes us backwards. Government truly wants to discuss constitutional change. It must do so in partnership with its tiriti partners. We're better than this. Anything less is unacceptable. Gisborne District Council stands firm in our commitment to genuine partnership, and we expect the government to do the same now and into the future. We remain committed to the government and tangata whenua to uphold te tiriti and achieve positive outcomes for all. Tēnā koutou, tēnā koutou, tēnā tātou katoa.
Ngā mihi, Nadine, and give our regards to Her Worship. Members, we've got a few minutes left if anyone wanted to ask a question. Huhana.
Tēnā koe, Nadine, and thank you for bringing the voice of local government before the Select Committee. You're on the front line in terms of the way that you work with tangata whenua for local government, for the RMA, and it's certainly been a journey. And we have the bigger conversation to happen this year in terms of the referendum on Māori wards as well. From your district council perspective, is this bill a messy nuisance of a distraction when really we need to be focusing on the big issues in terms of well-being, in terms of that infrastructure that we need across our rural communities? And, you know, do you have concerns for the taxpayer who is funding this process and the time spent as a community responding, knowing that we have been told
Huhana, I'm
by
going to ask
members
you to
of...
keep your questions concise because it's a bit
well,
of a
I'm going to ask
stretch,
her in terms of, is it a waste of time and resource for the people of New Zealand, particularly knowing that we have members of the coalition government who say that they're not even going to support it any further?
Kia ora. I would say that it is a distraction. It has taken us away from having to focus on the work that we need to be focusing and progressing forward. It's taken time and energy from thousands and thousands of people from across New Zealand to have to put in submissions, and public sector servants that are having to address the submissions, analyse them, present them, and support this whole process.
Kia thank you. Tākuta.
Tēnā koe te tuahine, me o kōrero. Last year we saw through the Māori wards legislation stuff, we saw mayors and CEs come to Parliament to present and talk about the good relationships that they now have with their iwi partners, their mana whenua partners. And that really made it clear that the local government people have done the work on the ground with their iwi partners, with their mana whenua partners in their rohe. Do you think that there's like a clear, well, there's obviously a lack of connection between central government and those same mana whenua people? And do you think that that's the case, that the local government is more connected to their iwi and their mana whenua people than the central government, and it causes problems like this one?
Oh, kia ora. I probably can't speak on behalf of central government workers and their relationships, but certainly at local government, we are at place, we are connected, and we're in the communities alongside our iwi and hapu and whānau. So I think that's why we naturally will have a closer relationship because of that. But like I say, I can't talk on behalf of central government.
Thank you, Nadine. Thanks for coming along, and appreciate you standing in today. But kia ora for that, and we'll bring the submission to a close. So thank you for that, and good to see you, Tiana. You've arrived just in time for lunch. We are breaking now, I think, until
just about hungry.
until 1:45. So
Right.
if we get back in, that'd be awesome. Kia ora.